call Madame Griffith, s'il vous plaît.
Monsieur le Sénateur Routier. Monsieur le Sénateur Ossoff. Monsieur le Sénateur McLean. Monsieur le Sénateur Gorst.
Présent.
Monsieur le Sénateur Farnham. Monsieur le Sénateur Balash. Monsieur le Sénateur Green.
Présent.
Madame le Sénateur Ferguson. Monsieur le Connétable de Saint-Hélier. Monsieur le Connétable de Saint-Clément. Monsieur le Connétable de Saint-Pierre.
Présent.
Madame le Connétable de Saint-Laurent. Madame le Connétable de Sainte-Marie.
Présente.
Monsieur le Connétable de Saint-Ouen.
Présent.
Monsieur le Connétable de Saint-Pralade. Monsieur le Connétable de Saint-Martin.
Présent.
Madame le Connétable de Saint-Sauveur. Monsieur le Connétable de Greville.
Présent.
Monsieur le Connétable de Saint-Jean. Monsieur le Connétable de la Trinité.
Présent.
Madame le Député Martin. Monsieur le Député Southern. Madame le Député de Greville.
Présente.
Madame le Député Hilton.
Présente.
Monsieur le Député Fondray.
Présent.
Madame le Député de la Trinité.
Présente.
Monsieur le Député Louis de Saint-Sauveur.
Présent.
Monsieur le Député Tadier. Monsieur le Député Noel. Madame le Député de Saint-Jean. Monsieur le Député Higgins. Monsieur le Député Masson.
Présent.
Madame le Député Pinnell.
Présente.
Monsieur le Député de Saint-Martin.
Présent.
Monsieur le Député Bryans.
Présent.
Madame le Député de Saint-Pierre.
Présente.
Monsieur le Député Rondel. Monsieur le Député Mézec. Monsieur le Député Louis de Saint-Hélier. Monsieur le Député de Saint-Ouen.
Présent.
Madame le Député Dublay. Monsieur le Député Labbé.
Présent.
Monsieur le Député Wickenden.
Présent.
Monsieur le Député Bree. Monsieur le Député Norton. Monsieur le Député MacDonald.
Présent.
Monsieur le Député de Saint-Marie.
Présent.
Monsieur le Député Truscott.
Présent.
Monsieur le Député McClinton.
Madame Griffith.
Prions Dieu. Notre aide soit au nom de Dieu qui a fait les cieux et la terre. Amen. Seigneur Dieu, Père éternel et tout-puissant, qui a établi les gouvernements et les puissances de la terre, pour le règlement et pour la conduite du peuple, et qui nous a commandé d'avoir toujours pour but la gloire de ton saint nom. Nous te prions qu'il te plaise de donner à cette assemblée le don de conseil et de prudence, d'unir les cœurs et les affections de tous ceux qui la composent, et de les conduire tellement toi-même par ton Saint-Esprit, que toute la délibération ait été accomplie de ta bénédiction, réussisse au bien au soulagement du peuple qui te plut de commettre à le soin. Car nous t'en prions au nom et par le mérite de ton Fils bien-aimé Jésus-Christ, notre Seigneur, qui nous a enseigné de t'invoquer en disant: Notre Père, qui es aux cieux, ton nom soit sanctifié, ton règne vienne, ta volonté soit faite en la terre comme au ciel. Donne-nous aujourd'hui notre pain quotidien, et nous pardonnons nos offenses, comme nous pardonnons à ceux qui nous ont offensés. Et ne nous induis point en tentation, mais délivre-nous du mal. Car toi, la reine, la puissance et la gloire, au siècle des siècles. Amen. Monsieur le sénateur Routier,
Malade.
je dirais que Monsieur le sénateur Routier est tellement indisposé qu'il ne peut pas assister aux états sans exposer sa santé. Monsieur le sénateur Ossoff,
So Senator Ossoff has been caught up in the weather conditions in the UK. He has now arrived on the island and will be with us shortly. I wonder if he could be defo excused, please.
Therefore, excusez.
Monsieur le sénateur McLean, Monsieur le sénateur Balash,
So Senator Balash is out of the island on state's business. I've just had that confirmed, sir.
Very well.
Madame le Connétable de Saint-Laurent,
Could I ask for a defo excuse for the Constable of St Lawrence? She has a long-standing parish function to attend.
Therefore, excusez.
Monsieur le Connétable de Saint-Pralade,
Default.
Monsieur le Connétable de Saint-Jean,
Présent.
Madame le Deputy Martin,
So Deputy Martin was due to come back from London City Airport at 9 o'clock this morning on a flight. It was delayed because of the weather, and so she still isn't here. I wonder if she could be defo excusée until such time as she gets here.
Default excusé.
Monsieur le Deputy Southern,
Présent.
Monsieur le Deputy Higgins,
Sir, Deputy Higgins has asked if I could point out that he has had a long-standing appointment representing a constituent, which was arranged before we decided that the States would be meeting on a Monday this week. So could he be marked excusé for that? And also just to note that he does have questions on the order paper. He intends to come back to the States as soon as he's done with this appointment, and has asked if I could ask if his questions could be put further down the list.
Members agree with Mark Deputy Higgins excusé.
Monsieur le Deputy Rondell, vous jurez que Monsieur le Deputy Rondell est tellement indisposé qu'il ne peut pas assister aux états sans exposer sa santé. Monsieur le Deputy Lewis de St Helier,
Default.
Madame le Deputy Doublé,
Present.
Monsieur le Deputy Bree,
My lord.
vous jurez que Monsieur le Deputy Bree est tellement indisposé qu'il ne peut pas assister aux états sans exposer sa santé. Monsieur le Deputy Norton,
Default. Les états sont constitués.
Sir, I wonder, I did just have confirmation from an official, but I've had further information which may mean that I've misinformed the Assembly about Senator Balash. I will confirm, sir, once I've had further confirmation. It may be that his state's business has come to an end, but he's still not quite returned to the island. Thank you.
Where were we? We're constituted. Good, we're constituted. First of all, under A, I'm very pleased to welcome His Excellency in the usual way to the sitting. B and C are as set out on the order paper. D, notification of lodged propositions. The draft Howard Davis Farm arrangements for further application of covenant Jersey law amendment lodged by the Minister for Infrastructure. That's an amendment to the amendment. Future Hospital approval of preferred scheme and funding amendment P107 lodged by Deputy Musson. Draft Data Protection Jersey law lodged by the Chief Minister P116. The Draft Protection Authority Jersey law P17 lodged by the Chief Minister. Draft Criminal Procedure Jersey law P118 lodged by the Council of Ministers. The draft amendment number 34 Standing Orders of the States of Jersey P119 lodged by the Privileges and Procedures Committee. The Social Housing in Jersey Introduction of a Regulatory Framework P120 lodged by the Minister for Housing. Minimum Wage Amendment of States Act of 21st April 2010 P121 lodged by Deputy Mezek. States Employment Board Living Wage 2017 P122 lodged by Deputy Southern. E-petitions introduction P123 lodged by the Privileges and Procedures Committee. Under E, in accordance with Standing Order 34.1, Deputy Southern has given notice of his wish to withdraw P72, the States Employment Board Living Wage 2017. Do you want to say anything, Deputy, about that?
Yes, sir. Because I hadn't received a response from the Chief Minister detailing whatever his reaction to the, I've been forced effectively to relodge, and I would like it parked on February 21st, if I could, for the meeting of February 21st.
Well, the Chairman of the Privileges and Procedures Committee has no doubt heard that request. The P95 Draft Petty Debts Court Miscellaneous Amendments Jersey Regulations to be withdrawn by the Chief Minister. Do you want to say anything? Well, there's nothing under F or G or H. We come to written questions under I. The Minister for Social Security will table an answer to a question asked by the Deputy of St Warren regarding the additional single parent component of income support. Minister for Treasury and Resources will table an answer to a question asked by Deputy Southern regarding the return to the guarantor from Andium Homes. Chief Minister will table an answer to a question asked by Deputy Southern regarding the Social Security review and the involvement of the Statistics Unit. The Minister for Treasury and Resources will table an answer to a question asked by Deputy Southern regarding the EU Code of Conduct for Business Taxation and Information on Company Profits. The Minister for Treasury and Resources will table an answer to a question asked by Deputy Southern regarding the funding of higher education tuition fees and maintenance grants. The Minister for Economic Development, Tourism, Sport and Culture will table an answer to a question asked by Deputy Higgins regarding agricultural grants and loans. The Chief Minister will table an answer to a question asked by Deputy Higgins regarding policies to reduce economic inequality. The Chief Minister will table an answer to a question asked by Deputy Higgins regarding policies to increase social mobility. The Minister for Health and Social Services will table an answer to a question asked by Deputy Higgins regarding the Department's complaints policy for children and vulnerable adults. The Minister for the Environment will table an answer to a question asked by Deputy Higgins regarding agricultural grants and loans provided by his department. And can I point out to members it's now 20 to 3. We have 16 questions, half an hour's questions to ministers, 2 urgent oral questions and 2 statements on matters of official responsibility. And so that's a lot to get through this afternoon. I may be a little more brutal than otherwise on supplementary questions. The first question, Deputy St John will ask of the Attorney-General.
Thank you, sir. Will Her Majesty's Attorney-General explain the legal context to the role of States members as the corporate parent in relation to children in care?
So the concept of the corporate parent is not one currently recognised under Jersey law, and individual States members, other than the Minister for Health and Social Services, do not have any specific responsibilities towards children in care, rather than to children generally. In England and Wales, a care order is made in favour of the local authority. In Jersey, a care order is made to the Minister, who assumes parental responsibility for the child, as well as other duties set out under the Children Law 2002. The independent Jersey Care Inquiry made the following recommendation, namely to emphasise the importance of this responsibility, namely corporate parent. We recommend the reference is made to this specific responsibility in the oath of office taken by members of the States Assembly. That's recommendation 6, sir. In that regard, the proposition lodged by the Council of Ministers for debate in January, P 108217, sets out the Council's response to the independent Jersey Care Inquiry and states that it is proposed that further policy development is progressed to describe the role of the corporate parent in legislation and more widely, and the opportunities this presents to ensure better outcomes for children. A key area of change highlighted in the inquiry report was the roles and responsibilities of elected members. The Privileges and Procedures Committee is considering the Care Inquiry's recommendations in this area and is expected to bring forward a proposition in relation to the oath sworn by States members and their induction.
Supplementary.
Thank you, sir. I appreciate the response from Her Majesty's Attorney-General. Could I just delve a little bit deeper in terms of understanding the corporate parent, as I understand it, with the Health Minister in terms of children in care, and then the specifics which the Attorney-General has just mentioned with relation to the Care Inquiry for all States members of this role or concept of corporate parent. Could the Attorney-General advise whether there would be any conflict or affliction in that particular role, considering what we have in a legal context for the corporate parent for the Health Minister and what we are seen as in terms of independent States members?
So I don't think that there would be a conflict, but of course the extent to which there might be will depend upon the definition of corporate parent adopted by due course by this Assembly. There is no definition, of course, yet in Jersey law or indeed in England and Wales. There is in Scotland, under the Scotland Children and Young People Act 2014, which clearly defines the responsibilities of the corporate parent, which extends to all Scottish ministers and thereby the government, and defines, for example, the duty of corporate parent
extending to be alert to matters which might or might adversely affect the well-being of children, to assess the needs of those children, young persons for services afforded it provides, to promote the interests of young children, children and young persons, to seek to provide them with opportunities to participate in activities designed to promote their well-being, and so on. I won't read out the whole list. So a wide scope of duties imposed on the corporate parent. In relation to the minister, his duties are more closely circumscribed under the children law, and they are principally the provision of accommodation for children and general duties in relation to looked after children, namely safeguarding and promoting their welfare, and to make such use of services available to children generally as appear to be reasonable in the case of the child concerned.
Deputy Greville.
Sorry, that was mistakes.
Final supplementary.
No, sir, I'd just like to thank the Attorney-General for his answers.
Yeah. Come to question 2, which Deputy Mezek will ask of the Minister of Health and Social Services.
Thank you, sir. Further to the Minister's comments to the Assembly on the 26th September 2017 that he hoped that arrangements to prescribe certain medicinal cannabis products would be in place by the end of the year, will the Minister provide an update on this matter?
Minister.
Thanks, sir. Thank the Deputy for his question. Sir, I have to say that I'm very disappointed that I'm not in a position to yet action this. But I can assure members that we are keen to move this forward with plans to recategorise specific named medical cannabis products. I have to say I'm somewhat frustrated that this is proving far more difficult than originally envisaged, and I apologise for that. Work on identifying specific quality control products is taking longer than we thought. So I can assure members that I remain committed to moving this forward as soon as I possibly can.
Supplementary, sir, and I'm grateful for the Minister's answer. Is he able to indicate any sort of new timetable by which he thinks he will be in a position to move forward with this, as he indicated earlier this year?
I'm not in a position to do that other than to say that I want to do this as quickly as possible. Part of the problem is the identifying clinically produced, consistently to the right standard products. That's one thing, and they're there, they exist. I've had some help from some what I might call patient experts in identifying that. So the second thing is finding organisations that are prepared to deliver here, not only deliver here, but actually other third-party countries allowing the product through where it's illegal in their country to do so. I don't think any of those are insurmountable, sir. They're just taking a little bit longer.
Deputy Tadier.
So could the Minister clarify who is responsible for, ultimately, for identifying the clinical products that can be signed off by himself?
So the advice will come from MDAC, the Misuse of Drugs Advisory Council, but specifically the individual concerned would be the chief pharmacist.
So does the Health Minister not think it's strange that we are reinventing the wheel? There are clearly countries out there who long before Jersey have legalised certain medicinal products for use in their own countries who are much bigger than Jersey is in terms of its population. And so why are we trying to reinvent the wheel on this particular issue?
So we're not trying to reinvent the wheel. We have to have an approved supplier, and that approved supplier has to be prepared to deliver to Jersey, sir. And the countries through which that must travel have to be in agreement to allow it to travel through those countries. So we're not trying to reinvent the wheel. We are not designing our own drugs. They are there, as the Deputy says, but we need to make sure that we can access them and have a good supply, sir, that's always of the right, consistent quality.
Sir, may I raise the defo on Deputy Norton, please?
Those defo be raised on Deputy Norton. Defo is raised. Final supplementary.
Thank you, sir. We're obviously not talking about an individual product here, but many products. Is the Minister able to indicate whether there would be any likelihood of perhaps some products being made available earlier than others, rather than waiting to do as many as possible in one batch? And does he foresee this as a process that may go on for some time, with more and more products being added to it, rather than simply waiting?
Exactly that, sir, and I'm hoping that there may be products that are easier to source and get online, and then that makes it much easier to follow on with the others, sir. So we're not waiting till we've got the perfect list. We're waiting till we've got a list that we can deliver, sir.
Come to question 3, which the Connaught Arbor St John will ask of the Minister for Home Affairs.
Thank you, sir. Will the Minister provide the cost to date for the training of fire officers and cover provided by the Fire and Rescue Service in place of the RLNI all-weather lifeboat? And will she also provide figures for the anticipated ongoing cost to the Fire and Rescue Service?
Thank you, sir. I'm sure members will agree that the first priority must be to ensure that all possible assets are available to save lives at sea. To that end, sir, I wish to commend the Fire and Rescue Services for the speed in which they have worked with the RNLI and existing volunteers from St Catherine's Lifeboat Service to bring the St Helier inshore lifeboat back into operational service. It took, sir, just 16 days. I think they all deserve our thanks in this regard. The cost to the fire service to date for the training of fire officers to crew the inshore lifeboat is £7,808. The other associated costs of training, which include backfill for firefighters being trained, RNLI trainer costs and medicals, total £31,987. These are all being funded by the RNLI. There's no future anticipated cost to the Fire and Rescue Service because the response and ongoing training will only be carried out by on-duty personnel, usually 1 or 2, whom are already paid to be on duty.
Supplementary. Right.
Yes, sir.
Senator Ferguson.
Is the 30,000 or so that's being funded by the RNLI coming out of the funds that are held in pool by the RNLI on behalf of Jersey?
I'm not sure that's a matter for this Minister, Senator. I don't see how this Minister could answer that question. Any other supplementaries? Very well. Then we go to question 4, which Senator Ferguson will... No, we've just moved on. We'll go to question 4, which Senator Ferguson will ask of the Minister for Health and Social Services.
Further to his answer to written question 1(175) on the 28th of March 2017, will the Minister set out which services are currently undertaken in the existing hospital and are not planned to be undertaken in the new hospital?
Minister.
I know you want us to be fairly speedy, sir. The answer to that question is in 175, so the list of all the services that will be provided. It runs to over an A4 page, so I'm sure you wouldn't want me to read them out, sir. All the services that you'd expect to find in a district general hospital will be provided in the new hospital as now.
So that it is said that services such as the chapel and the hydrotherapy pool are still questionable. Can the Minister confirm that these will both be provided within a new hospital?
I can absolutely assure members that in terms of the chapel, there will be a faith facility within the new hospital. And in terms of the hydrotherapy, sir, there will be a hydrotherapy service. It is one of the first things we have to knock down on the new site, but there will be a hydrotherapy service, sir.
So, before we take the next... Oh,
sorry. Just so that I understand, Minister, does that mean it may not be provided in the new hospital?
So what we have to do is to remove the hydrotherapy service currently where the new hospital is going to go. And we're investigating whether that would be a permanent move or a temporary move, sir. We don't know the answer to that yet.
Supplementary, Deputy Southern.
Yes, sir. Will the Minister elucidate for members how many services he intends to relocate from the hospital into the community, and whether those services will require direct payment like GPs do currently?
So this is slightly different. There's nothing to do with the new hospital directly. This is to do with modernisation of our services. And we have a couple of pilot schemes at the moment in terms of delivering diabetes, for example. And the very question the Deputy asked about who pays, that is under investigation at the present time, sir.
Sir, if I may I ask the Minister when he is likely to come to the House with some costed provisions for the supply of services in the community other than GPs?
I'm not sure I understand the question. I wonder if the Deputy could repeat it.
Yeah, when can you come to the
Assembly.
members, to the Assembly, with costed plans as to what services will be delivered in the community and what price they'll be?
So the plans for services delivered in the community generally are contained within P82. The costs or the money needed to do that will be in the budget, sir, or in the next MTFP pre, sir. I don't think I can say much more than that at this stage.
Would the Minister point me to the right page on P82, because I haven't seen them?
Deputy Sergeant, thank you. Deputy Levy.
Yes, I don't think I'm the only member who's getting representations on behalf of the hydrotherapy unit and the hospital. What are we to tell people who are concerned about this? Will there be a hydrotherapy pool in the new hospital, or will patients requiring that have to go to the splash pool on the waterfront? Could the Minister elucidate, be a bit more clearer about it?
So as I said before, when I answered the question originally, there will be a hydrotherapy service. I know how important it is, so I used it myself recently. There will be a hydrotherapy service, but it is one of the first things on the site where the new hospital's going that has to be removed. Now, it's expensive to move them twice, so all I'm looking at is whether we can do it on some other premises, maybe in health, but there will be a hydrotherapy service, sir.
Final supplementary.
Sir, if I may.
Soon.
Could I ask the Health Minister to reconsider his answer when he referred to P82, because P82 was a very broad and generic document which may have contained some figures in the overall spend and savings that were going to happen, but did not elucidate, I believe, any particular services to be delivered in the community. Will he reconsider that answer and amend it appropriately?
So I will reconsider the answer I've given when I fully understand the question, sir. So I'll take the opportunity to discuss it with the Deputy afterwards, make sure I fully understand what it is, because I want to be transparent and open, and then I will forward the answer to all members, sir.
Final supplementary.
Thank you, sir. Amongst the services we offer at the hospital are 40 bed sits, 7 one-bed flats and 9 two-bedroom flats at Westerway Court. And I understand that the 40 bed sits will be transferred to the Limes, and the other two, the 7 one-bedroom flats and the 9 two-bedroom flats, is an unspecified relocation. In other words, it'll be up to the people occupying them themselves. Why are we doing that when we're so short of accommodation in the island?
We also need a new hospital. And when the Senator asked me the question about facilities in the hospital, she didn't particularly ask me about staff facilities, otherwise I would have been able to answer that directly. So we are working on a key worker accommodation process. Meanwhile, we have the Limes being, as the Senator says, being renovated for junior doctors, sir, and we will be supporting our staff in those that are in Peter Krill House at the moment. We need to clear that site in order to have a new hospital, sir. A hospital that is urgently needed, a hospital that this community wants.
Supplementary, sir.
No, that's your last. That was your supplementary. That was the last one, sir.
So could I raise the defo on the Constable of St Brillard's?
Propose the defo be raised on Constable of St Brillard's. Defo is raised. Come to question 5, which Deputy Tadier will ask of the Chairman of the State's Employment Board.
Thanks, sir. Since I lodged this question, sir, the report has just been given to me and it's arrived on my desk this morning, which means that I need time to digest that, and I'll be withdrawing the question, sir.
Thank you. We'll come to question 7, which the Deputy of Greville will ask of the Chief Minister.
Thank you, sir. Given the adoption in November 2014 of my proposition P149-2014, Questions I asked in February 2016, January 2017 and July 2017, and previous advice from the Chief Minister that work was underway and that he would bring forward measures to include wholly owned and majority-owned states entities within the Freedom of Information Law. Will he state what has happened and why that decision of 3 years ago has not been implemented?
Thank you, sir. So I outlined in July that a review, and that review is taking longer than I anticipated, and I'm sorry to say that that remains the case. Therefore, sir, in the final months of this term of office, I'll do what I can to deliver on the Assembly's decision.
Supplement.
Yes, I would, sir. I would like to understand a bit further about this delay. Is it a case that it is not a priority of the officers that are meant to be working on it, that they don't have enough time, or is it a lack of political will? Because after all, it was the Council of Ministers who predominantly voted against this coming forward. So I would like to understand where the delay is. Thank you, sir.
So it's probably all of those areas, officers in my department, particular officers undertaking this review, are extremely busy. It is quite a complex area to separate out those areas that would be subject of FOI and those that would be commercially sensitive. And there are another number of improvements and refinements to FOI that need to be made. And if I'm honest, sir, I have to say that with all of the other workload that I've had, I've not given it the priority that I ought to have done, and that's why I gave the commitment that I did at the end of the answer.
Senator Ferguson.
Thank you, sir. I can't see that this is that complicated, and it would prevent extreme frustration for the public. Would the Chief Minister give an undertaking that this will be brought in before next May?
So I'm not going to make a double error. It's taken longer than I had hoped for, and I can do no better than to say that I'll do all that I can to try and deliver a decision to this Assembly in order for them to vote on it. Thank you, sir.
Sir, could the Chief Minister explain why a review is actually needed in this respect? The states agreed that the actual company should come under the Freedom of Information Law. So is the Freedom of Information Law being changed because of the companies or because there's actually problems with the Freedom of Information Law?
So a review was started to cover the bringing together of these companies. When we started that review, we became aware, and I think have been aware for quite a while, that there are some deficiencies, some areas where the public should have greater access to information, and some areas, in order to deliver appropriate policy-making conversations, there needs to be refinement in those areas. It is possible, sir, that we could perhaps pull it out of that review and just bring those changes forward, but it would leave the other areas which are deficient then to a second stage.
Deputy Laddie.
So when the States Assembly backs a backbenchers proposition, as with the Deputy of Greville's P149 in 2014, and that decision is not enacted by the Council of Ministers, is that a deliberate and considered appropriate assault on the primacy of this Assembly, or just an accidental one?
So it wasn't deliberate. I could have stood up here, as I've done on other occasions, and given several convoluted excuses. That wouldn't be right. It hasn't happened. I stand to say sorry that it's not happened, as I did in my opening comments, and I'll endeavour to correct that situation.
Final supplementary.
Thank you. I'm willing to accept that, well, that the laws might be complex, but they're not so complex. If these entities were actually part of the states, they were states departments before, and if they were still now, they would be subject to freedom of information. The parishes have done their bit. They've come on within the law. So it's not beyond the wit of man to get these entities into covered by the freedom of information law. I'm not prepared really to accept that as an excuse, but what I'm absolutely not prepared to accept is the lack of political will, because when I offered that as a possible reason that it hasn't come forward, the Chief Minister said all of those reasons. Well, I'm not...
And the question?
Well, the question is, sir, does he not agree this is unacceptable? Thank you.
So I do agree it's unacceptable. It would be disingenuous of me to say that I have to admit that it's not been a priority with all of the other priorities that I've had to navigate over the last 3 years. I stand, sir, to say I apologise to the member for that, and I'll do what I can in the remaining months of this term of office.
We come to question 8, which Deputy Mussall will ask of the Minister for Treasury and Resources.
Thank you, Stan. I do appreciate in some ways I've been superseded by events. Will the Minister, as shareholder representative, explain why the fencing which Save Jersey's heritage has been reported as describing as inappropriate has been erected at St Catherine's? Will he request the Ports of Jersey to remove it and deal with the area differently, and if not, why not?
Minister.
Sir, I'm going to ask my Assistant Minister to take this question, as he has responsibility for shareholder matters.
Thank you, sir. So the Ports of Jersey have advised me that a rock stability survey was carried out at the beginning of this year. This showed increased safety concerns that crumbling rock may fall onto members of the public passing nearby, and that their responsibility for the safety of the public is uppermost in their minds. Furthermore, there have also been recorded incidents of unauthorised attempts by persons trying to climb the unstable rock face of Gibraltar Rock without any permissions or protective equipment, placing themselves and passing members of the public in further danger. Public safety in all areas of the Port's responsibilities remains an absolute priority for the Ports of Jersey at all the sites they control, and the installation of this fencing was considered to be necessary in order to maintain the safety of the public. Thank you, sir.
Supplementary.
Thank you, sir, and I appreciate that. Since this time, Ports is looking to change, I believe has changed the look of it. But therefore, does the Minister think that perhaps a change to the Memorandum of Understanding or Articles of Association for the protection of the public realm for this and other states-owned bodies should be looked at and reviewed and brought forward? Because, of course, the big issue about this is not only heritage, but the tourism aspects of the area.
So I personally don't think that it's appropriate to change the Amendment of Arts on this particular topic. That is a matter for the Planning Minister if he feels it appropriate to look at the ability for ports to do certain works without first taking it through his department. I think it would be fair to say that the Ports of Jersey have recognised their error in racing in with this work with some equipment they already had in stock, rather than buying in more suitable equipment to provide that public safety element, sir.
Yes, sir. I wonder, would the Assistant Minister like to explain how we are going to put the whole of the island into cotton wool to prevent people falling over and hurting themselves?
I'm not quite sure I can answer that question, sir. I don't think there is an intention to do so. But however, in these days, modern days of litigation, we have to be prepared to protect ourselves from that very litigation, sir. Thank you.
Constable Saviour.
Sir, just going off the piece ever so slightly, if the Port of authorities are worried about the islanders, why did they withdraw our lifeboat?
No, that's not for the Minister for Treasury and Resources. Deputy Lavey.
How many people have been killed or injured by falling rocks in the island, which which would call for the fences to be erected?
None to my knowledge, sir. However, the Deputy and other members may recall that part of the Snow Hill car park was being closed for quite a fair number of months by the Department of Infrastructure for that very purpose. to avoid rocks coming from the high ground above that onto people walking through the car park. I'm afraid we have a responsibility as States Departments to make sure that when we are advised that there is an inherent danger to the members of the public, that we take steps to remove that danger. Thank you, sir.
Final supplementary.
Thank you, sir. If the Assistant Minister doesn't think that the MEMS and arts are the way to do this, whilst I appreciate the Ports Authority has now accepted that a different approach is needed, of course the individuals in post, of course, are only temporary. Perhaps can the Assistant Minister suggest what could be done in order to make the protection of the public realm of lands owned or organised by ports, that the protection of the public realm is there is agreement on an ongoing basis that that type of thing should be protected, and do we need something in writing in order to back that? That's what I'm trying to get at.
So the Deputy makes a good point there, and I certainly am quite happy to undertake to raise this matter further with Ports of Jersey, and whether there is a requirement for them, although they are, in many cases, they don't require planning permission for some works, I don't consider it to be inappropriate for the Planning Minister to be advised of works they intend carrying out to ensure that he, on our behalf, is happy with them. Thank you, sir.
We come to question 9, which Deputy Southern will ask of the Chief Minister.
Thank you, sir. Given Jersey has been placed on the EU grey list of tax jurisdictions, will the Chief Minister explain how he proposes to reform Jersey's tax system to ensure, for example, that the tax regime does not facilitate offshore structures which attract profits without real economic activity? And will he state further which company structures he proposes should be affected by any such reforms?
Chief Minister.
Thank you, sir. Jersey is committed to the OECD Common Reporting Standard, to the OECD Multilateral Instrument on Base Erosion and Profit Shifting, and to the exchange of notes with the UK Government on sharing beneficial ownership information. This government has an excellent track record of meeting international standards and will continue to do so. It would, however, be wholly inappropriate for me to prejudice our interests by speculating on solutions at this stage.
In that case, sir, far from speculation, will the Chief Minister lay out a clear timetable for the reforms required to meet the EU needs, specifying exactly what each change might be and when it might happen? Will he do that?
So the Deputy will be aware that I'm due to make a statement later this afternoon on this issue. With that statement, I will be including a copy of the letter that I've sent to the Chairman of the Code of Conduct group, together with a timeline of working together and entering into dialogue with the Code group to address their concerns, something which is wholly different from what the Deputy is trying to suggest, sir.
Deputy Goodall.
Yes. Sir, perhaps you can help me with this, or the Chief Minister. Is there such a thing as a grey list? Because if there isn't, surely the question is hypothetical.
Well, it's been put in inverted commas and is therefore something close to a euphemism, not quite on the white list, as I understood it. But,
so, of course, I'm not the one that authorises questions. There is no grey list. I have been quite clear. There is a black list. The Deputy should know that. But, of course, he is siding with our detractors by trying to refer to it as such.
Final supplementary? Oh, no, Deputy Teddy.
Thank you, sir. In a previous answer by the Chief Minister, he stated that there are circa 45,000 companies considered to be resident in Jersey. And he goes on to say that data was available in respect of 13% of the companies considered to be resident in Jersey. If we don't know what profits are made by and where by 87% of companies in Jersey, how can we perform due diligence in sharing information, when we only know about 13%, not the other 87%?
So because we're following international standards around country-by-country reporting and the BEPS agenda, and that's what we'll continue to do. and we're meeting those requirements for the exchange of profits information. We're meeting the requirements under the common reporting standard for exchange of information automatically, and of course we are gathering more and more information around these issues as well to ensure that we can deal with questions as they arise. But the Deputy should know, sir, that the concerns are around trading companies and not investment holding companies, and it's that area where we'll be working, I think, particularly with the EU.
And final supplementary?
Yes, sir. And despite his false allegations, I would put to him the question as to respond as to what future he sees for the 010 tax policy, since the EU Code of Conduct Group on business taxation are now very clearly signalling it is unacceptable to them. We've ducked this issue once when we went to 010. Does this not mean the end of 010, one way or another?
So I would have expected that the Deputy had read the documentation as he has asked a question on it. He will know that there is a gateway in the screening process criteria which is around 0, but he will also know that it was not a criteria in itself, and the criteria was around economic substance, and that is the commitment that I have given, because as I've said in this assembly previously, sir, as I've said in the public domain, that work around economic substance is already undertaken by the regulator when it's an issuing a licence to a regulated entity, and we're also, sir, we'll explore notification regimes as well. That's not about the 0, sir, but yet again, the Deputy will groan and shout at me across this assembly, but he sides himself with our detractors who suggest that we're not meeting the relevant international standards, that shows a lack of understanding of what happens in our financial services industry. And so I don't think that's acceptable.
Sir, can I have a ruling on his, I believe, intentional impugning of my integrity, saying that I line myself up with our opponents?
Deputy, I don't see that as being something which impugns your integrity. It's there will be people who are detractors of the island who might be right in that, and there will be people who are detractors of the island who might be wrong in that. This is a matter for political debate.
I thank the Chair. I'm very relieved.
We come to question 10, which Deputy Tadier will ask of the Minister of the Environment.
Sorry, sir, I was just pondering other issues. Excuse the delay. Further to an incident earlier this year in which a 10-year-old Japanese Spitz died after ingesting forate at Le Creux Country Park, what further steps, if any, will the Minister take to ensure the possibility of such instances recurring are minimised in the future?
Thank you, sir. Sir, the incident this summer that caused the death of a dog as a result of it consuming a banned pesticide was indeed a very tragic one. My department and I place great importance on the safe sale, use and storage of pesticides, and we investigated this case and searched the area where the dog was walked, but did not find any sign of old containers or pesticides. We also checked historic pesticide records and stores in the area for signs of forate, the pesticide that killed the dog, but again did not find anything. While we don't believe there's anything other than an extremely small ongoing risk to pets, we advise dog owners and walkers to remain vigilant and report any concerns they may have to my department. States members may also be aware that the department's pesticide amnesty, which following the death of the dog we re-advertised. This allows members of the public to bring out-of-date and revoked pesticides into the department without fear of prosecution. Sir, I believe the current wide range of audits and enforcement activities we undertake to ensure that risks from pesticide are minimised to be adequate and appropriate. Whilst this type of incident is very sad, it is fortunately also extremely rare.
Supplementary.
Thanks, sir. Can the Minister confirm, if not now, by circulating the information as to what levels of the chemical 4-8 were in the dog system? And has he ruled out that the case may have been malicious?
So I will attempt to find out the level of 4-8 that was used in the poisoning. I can't rule out or rule in anything particularly. I did do some research. Obviously, our state's vet was heavily involved in this. The animal was tested twice to make sure and ascertain correctly that 4-8 was indeed the chemical that was used. This is a chemical which was banned in 2003. So it's still a mystery to my department as to quite how this dog happened, unfortunately, to be poisoned by it. It's a chemical when applied on ground and in the air, it usually disperses within 2 to 3 weeks. So this case is still a mystery to us.
Deputy St John.
Yes, thank you, sir. When the press release came out from the department with regards to this, I was quite astonished that the department stated that they think there's no future threat of this 4-8 coming forward. So I questioned the department further. I need to ask the Minister whether he thinks the Pesticides Jersey Law 1991 is sufficient for the ability for his officers to investigate and whether there is sufficient resource to carry out the relevant roles.
Sir, the current pesticides laws are quite onerous. We adopt a list from the UK, which we accept in Jersey as the approved list, but we regularly remove chemicals from this when they're banned or the licence expires, and I would quote the recent case where I took the pesticide Linuon off the list. So we have very rigorous testing of the chemicals we use. We audit very heavily every chemical which enters the island. We have continuous dialogue with the people who sell it. People who use it have to be certified to buy chemicals from authorised dealers, and the people who apply it have to be certified and use equipment which is calibrated for the purpose. I don't know what more we can do in this day and age, but I can only say to the Deputy, back in 2003 we weren't as stringent as we are now, and I can only reaffirm that how this particular chemical, and again it was a mystery, which is why we tested for it twice, how this particular chemical has even survived to this day in the island is still a bit of a mystery.
Sir, supplementary, can I ask the Minister whether he thinks it appropriate that the department randomly inspects only 20% of all pesticide stores annually and at that point removes out-of-date or revoked products, and whether there is further work that the department could be doing to ensure that should this be some form of malicious intent, that they would be able to identify and investigate further?
So it's right to say that we only routinely look at 20% of chemical stores on the island, but I can say to the Deputy that if we have any inkling that something is not right, we have obviously the ability to inspect spray records at a moment's notice. We have the ability to inspect spray canisters or containers at a moment's notice. And through the work of the Cleaner Water Group, we are identifying areas. We're doing an awful lot more testing of water courses. We're picking up chemicals that we may not have seen before, and we go back and test. We have an excellent rapport with the industry, but of course I have to say to the Deputy, if people want to hide things from us, it's it's not a particularly difficult thing to do. And like anything, if farmers are, or anybody for that matter, is determined to hide a chemical away somewhere, that may well be done. But we make every effort we can. We've reduced to 20% to save on officer time, but I could only reiterate to the Deputy that if we have the slightest inkling that something is out of order, we inspect records and we speak to farmers immediately.
Final supplementary, Deputy Teddy.
Yeah, thank you, sir. I'm obviously asking this question on behalf of a constituent, but as there are many dog lovers in Jersey, it's, I think, germane to many of us. It seems to me that a dog wouldn't naturally seek to eat 4-8 or a similar substance under normal circumstances. That means that it was probably either eating food that had been contaminated with the product or perhaps eating an animal which had subsequently died after eating the product. Either way, it suggests that there may have been some malicious intent, and if that was the case, would the department liaise, continue to do work to make sure that people aren't acting maliciously in such cases.
Thank you, sir. Sir, I'm reassured by the fact that a number of dogs get walked in this area every day. In fact, I've walked my own dogs there, and I know it's an area that's heavily used. The fact that no other dogs appear to have suffered any ill effects in walking in this area is some relief to me. But I can only say to the Deputy that I understand his sentiments. He doesn't need to go into any more depth, and I will speak to the States Vet about this and see if any further action needs to be taken.
We come to question 11, which Senator Ferguson will ask of the Minister of Economic Development, Tourism, Sport and Culture.
Thank you, sir. What was the cost, if any, to the states of the RNLI lifeguards when they originally were employed, and what is the current cost?
Minister. Minister. On question 11.
Sorry, sir, I beg your pardon, sir. This is the Assistant Minister with responsibility for that sector will answer it. Thank you.
Commenter.
Make that clear. I thank the Senator for the question, and it's a really pleases me to give me the opportunity to highlight the incredible work that the RNL lifeguards do on our beaches around the island. To cut to the chase, the contribution made by the State of Jersey increases by RPIX annually once any changes in service increases or decreases have been agreed. But the contribution in 2011, when the contract was first taken out, was £150,000. The contribution in 2017 was £222,644.
Supplementary.
I wonder if the minister could, the assistant minister could just clarify something, because I did ask one of the civil servants, and he said it was 276,000 a year.
So I can only go by the information given to me by the officer that deals directly with the RNLI and the service here, and the figure I've got in front of me here for 2017 is 222,644, which sounds correct to me because the figure in 2016 was 218,278.
I wonder then if the assistant minister would tell us when the contract is to be renewed, will it be going out to tender, and would he like to just check the 276,000 question as well, please?
Doing the last bit first. Sorry, sir, doing the last bit first. I am sure that figure is correct because I was the one that signed the original the contract in 2015. So I'm sure that that figure is correct. In regards to the tender, in regards to the service that they offer, the contract is, I think, is due to be renewed at the end of or to be reconsidered at the end of 2018. That's a 4-year period. At the current time, no decisions made as to whether it will go out to tender. But all I will say is that when this service first moved from the States to the RNLI, the service the RNLI took over faced a huge unfunded bill for investment in equipment, and we relied on lifeguards from overseas. We now have all our lifeguards locally trained. In fact, we export our lifeguards around the world to do work elsewhere. And I like that. I think it's good, and I'd like to keep that. But no decision's been made in regards to whether it will be tendered out, but my own preference would be it stays local. And we work with the RNLI, who have provided an excellent service, as I say again, who provide equipment far and above the cost in regards to pounds, shillings and pence, and who have just invested in a brand new facility at Bowmore, which I have to say, having visited it recently, is quite an investment considering what we actually pay each year for the service.
One supplementary? You don't have to.
No, sir, I would just like that 276 figure to be. I appreciate that the minister signed the last contract, the last decision, but perhaps he would like to ask his officers just to check and make sure, please.
Sir, I'm more than happy to, and in fact, sorry. I'm more than happy to. In fact, I have the contract here, so I will personally hand it to the Senator while we're here, and she can have a look at it, sir.
We come to question 13, which the Deputy of Grouville will ask of the Minister for Infrastructure.
Will the Minister state when his policy of pursuing payments for encroachments on the foreshore, which he claimed some months ago would be forthcoming, will be ready, and advise whether it will include the date and maps he intends to use to identify any encroachments?
Minister.
Sir, I am pleased to inform the Deputy Grouville and indeed other members that I actually signed the ministerial decision earlier today approving the foreshore encroachment policy and the associated departmental procedures. The decision and accompanying report and the policy will be made available to members and of course to the public in short order, sir, as soon as it can be uploaded onto the gov.je website. And the policy and the associated procedures do not include dates of maps which may be referred to for identifying the encroachment, sir.
I'm rather astounded that a decision such as this is being taken just by the Minister, and that land that was given to the island from the Crown just 2 years ago is now being treated in this way. I would like, well, like I say, I'm just a little stunned at that answer. How is the Minister going to, how does he know, and if he's not using maps and dates, how do people know when the encroachment may or may not have occurred?
So that's a very good question, and I suspect that the Deputy may have been incorrectly informed if she understands that maps, a map or maps exist which show a line or boundary line between the foreshore and private land. The upper extent of the foreshore is the high water mark, and in all encroachment cases it is necessary to assess where the high water mark would have been before the encroachment took place, and in some cases that is fairly straightforward, sir, but in other cases it is more difficult. In dealing with the foreshore encroachment since the early 1990s, Property Holdings and prior to that Property Services and the Law Officers Department have retrieved and studied a number of drawings relating to the various parts of the foreshore, generally drawings from which seawalls were built. These drawings have often proved to be very useful in determining that the foreshore extended behind the seawall, which in most cases is the obvious reason as to why the seawall was built. Each encroachment case has to be studied on the best information available, which is reference to transactions, contracts, possibly drawings, possibly historic photographs, and possibly historic papers such as committee acts. In our experience, sir, it is very rare that a party which is suspected of encroaching can produce information to contest our belief that the foreshore has been encroached upon.
Deputy Levy.
Thank you, sir. The actions that have been taken on perceived encroachments and settled, is that in perpetuity? And what implications does that have for plans in the future, maybe, to have a cycleway or walkway on the seaside, on the sea wall, from the Dyke to La Roque?
Sir, firstly, I'd like to correct the Deputy. There were no perceived encroachments, sir. They were encroachments, and they were proved to be such, and the negotiated settlements around that vary from case to case. Some are in perpetuity, some are shorter-term agreements, sir.
Deputy Martin.
Sir, just a question to the Minister. I think he said that the people find it hard to prove against the Ministry. So is there an appeal system? And if there is it not just to the Minister? Because it just seems, from what I heard him say, it was sort of a fait accompli. Our judgment is final.
Sir, that's not the case. As I've explained in the Assembly before, all settlements with third-party landowners are indeed those. They are settlements. They are negotiated settlements. So there is no fait accompli. The criteria is should we do nothing if there's an encroachment identified? That is obviously not something that the public would want to do. Can the area be reinstated, i.e. remove the encroachment? Or if that's not the case, or if there's good reasons not to pursue removal of the encroachment, that a negotiated settlement is made, sir.
Deputy Greville.
Sir, I cannot understand how the Minister is defining the encroachments. If you take, for example, Victoria Avenue, the Esplanade, the Weybridge, that was our seafront. So the whole of the waterfront, the way I see it, is an encroachment. So will he be going after Ports of Jersey and fining them as he's doing to private landowners in other areas? It doesn't only affect St Helier, it affects all around the island. And I really do not understand how he is able to get away with this, sir. How he's able to fine people for encroachment when there's no date and there's no map. I look forward to further explanation. Thank you.
So now that the policy has been finalised, I repeat my invitation to the Deputy and indeed any other member who wishes to meet with my department and the Law Officers Department to go through the policy and the procedures and to go through how the law officers verify whether or not there has been an encroachment. So I do not define myself or my predecessors or my successors the Minister will not define what the encroachment has been. We take legal advice for that, and it is the legal advice that we act upon, sir. And I believe the Deputy may be have a misunderstanding with regards to the foreshore around the port of St Helier, sir. That land was transferred from the Crown to the State, sir, for the States to be able to reclaim that land. That is the sort of the high-level man in the street version, sir. I'm sure that there was actually a more legally precise definition of what actually took place. But so there was no encroachment on the foreshore because it was ourselves that took up that opportunity to reclaim that land.
We come to question 14, which Deputy Mezek will ask of the Chief Minister.
Thank you, sir. Following comments made to the Assembly by the Assistant Chief Minister, Senator Routier, and a public statement he released in April about the prospect of an independent public inquiry into the sacking of the RNLI Coxham, what progress, if any, has been made in setting up this inquiry?
Chief Minister.
So I ask the Deputy St Martin to answer this question, please.
Thank you, sir. Sir, since the time when Assistant Chief Minister Senator Routier was asked by the now former lifeboat crew in April to investigate, we have spent considerable time talking with many people, including the crew representatives, the Royal National Lifeboat Institution, Coast Guard, the Harbour Master, Ports of Jersey, and many others. We have emphasised to the RNLI the importance of having a crew with local knowledge at all opportunities. The outcome of our investigations have resulted in acceptance by all parties, and all parties recognise that they had had opportunities to intervene earlier in relations that have now deteriorated over several years. We established that there was a desire to acknowledge and move forward. On that basis, the Coxswain was reinstated. As part of this reinstatement, all parties, Government, Ports of Jersey, the crew, and the RNLI, agreed that a fresh start would be made and a line drawn under the past. We're extremely disappointed that this has not been possible and it's been possible to move forward on this basis. However, if evidence is presented to government that merits an independent inquiry, then we will pursue one. For the avoidance of doubt, to date, no such evidence has been presented.
Supplementary, sir. So I take it from that answer that the independent inquiry that was suggested earlier this year has not taken place and, as things currently stand, won't take place. I attended one of the meetings that has been hosted recently by the crew and the those who are trying to set up an independent lifeboat service, who indicated that they still felt that there was value in having an independent inquiry and that they felt that it would help the full picture be better recognised, not just by them but by the public, And given this is such an important subject, and where I think many people are actually quite divided on what the solution is, does the Minister think that actually there is still merit in having this public inquiry, and would he endeavour to propose such a thing?
Sir, I'm happy to agree with the Deputy. I have said on a couple of occasions in the very recent past that exactly what the Deputy's just said. There are a lot of questions unanswered. People come to me, and I know other politicians are asking questions that the answers aren't forthcoming, and maybe it is time that this evidence was put in the public domain. Quite what the title of the public inquiry will be, I don't know. I have very little evidence to put forward to whoever runs that public inquiry, and I think I'll have to investigate further. But certainly in answer to the Deputy's question, I absolutely agree. It's time we had some answers to many of these questions, and I will see what I can do to bring that forward.
Deputy.
Yes, thank you, sir. It appears to me that the Minister got things completely the wrong way round. He's saying, bring forward some evidence and we'll hold an inquiry. Surely it's an inquiry that brings forward the evidence and examines it. Isn't that the correct way round when dealing with an inquiry?
So I have to say to the Assembly, we've had two sorts of inquiries already in this case. There was the situation where the coxswain was suspended. There was an inquiry into that, and the outcome of that inquiry eventually was the coxswain being reinstated. I know that the coxswain has asked for a record of that inquiry, and he's received a redacted record. Members may know that he's now asked for the unredacted record, but has been told that the institution have acted legally and they're not in a position to give him an unredacted record. I believe he's potentially pursuing that in other directions, and I have spoken to him about that on a number of occasions. I'm not aware that that's moving forward. The second inquiry that has been taking place was into an employee of Ports of Jersey. Again, this was a complaint that came from the ex-coxswain. That inquiry took place and was found that there wasn't any merit in it. And again, the coxswain had a meeting with the Chief Executive of Ports, and that message was conveyed to him. So we have had two inquiries thus far, and I'd like to see some more evidence to move forward. But again, I will take the sentiments of the Assembly on board and go away and see what I can do.
Deputy, no, I'm sorry, Senator Ferguson.
Thank you, sir. Yes, I know that the Minister is calling for evidence, but unfortunately the evidence is either redacted or unavailable because of freedom of information restrictions with organisations such as Ports. And I think what people are asking for is a copy of the investigation by the RNLI and an investigation of the part played by employees of Ports, which isn't available. Perhaps the Minister would like to consider this and perhaps talk to the Chief Executive of Ports and the Board.
Certainly, sir, I'm happy to do that. I do wonder if I'll face a similar situation where a report may not be released to me. This was an internal inquiry, but I will take the Senator's sentiments away and see what I can do.
Deputy Levy.
Thank you, sir. I get that the Minister is promoting what seems to be the party line from the Council of Ministers, that the focus is on getting a lifeboat up and running as soon as possible back out of St Helier. But what about the focus on support and gratitude and honouring the work of Coxswain Hibbs and his crew? Because the public of Jersey seem to feel that the Council of Ministers are working in cahoots with Ports of Jersey and cutting the old life crew adrift.
So I can only reiterate what I've said to the Assembly in the past. The priority at the moment is to get lifeboats back in St Helier. I receive daily emails about the risks to mariners around our shores and the risks of not having an all-weather lifeboat in St Helier. And while the Harbour Master is satisfied that while the risk is greater than it was, it's still manageable, and we are doing everything we can to get that situation remedied. I have never had anything but complete admiration for the coxswain and his crew for going to sea in all sorts of appalling weather in the past, and I've never ever said anything other than that. This is a relationship matter between the crew and the Royal National Lifeboat Institution, and as I said in my original answer, we agreed some time ago now that situations which could have been handled differently some years back were not, and things have deteriorated since that point. But I can only say to the Deputy, at no time ever have the question, the bravery, integrity of the crew and the coxswain in going to sea on our behalf to save people at sea has ever been in dispute.
Deputy St John.
Thank you, sir. And I'd like to thank the Minister for providing a briefing to States members last week. But I will reiterate my concerns now as to what I reiterated at that briefing. My view is that there needs to be absolute openness and transparency around this. And our responsibility as a States Assembly, or your responsibility as a government, in terms of holding Ports of Jersey to account to ensure appropriate conduct. And I think openness and transparency in that matter is absolutely vital. So would the Minister ensure that any review, anything that happens with regards to holding to account the Ports of Jersey is done in an open and transparent manner so that everybody can see exactly the facts of what's happened in this case and everyone can have light of all sides of the story?
So I'm not sure that I'm in a position today to say to the Deputy that yes, absolutely I will do that, but I can certainly guarantee to her that I will go away and do everything with my power to make that happen.
Final supplementary. I think she was just a fraction late for right, Deputy Martin.
Oh no, I did. Oh God, no. I did have my light on
Well,
before.
maybe it was hiding behind the Deputy Martin.
Can I go? Oh, thank you. Yes, and I thank the Minister as well for his answers. But it is the public, and it is about transparency. And does the Minister not agree that from the public and me as a States member, this is one of our fourth emergency crew, and if it was any other of the paid, the police, the fire or the ambulance, and they had a dispute, and we, or the States, under a ministry, had gone out and asked for new volunteers, what would that look like? And then what does it look like? So this is what I'm getting, and can the Minister dispel this for me and the rest of the public once and for all? Because it's basically, that's what I feel. Sorry, you didn't, we can't work out if you were gone out and we're going to get another crew, and you couldn't do this, as I say, with the police, the fire or the ambulance. The whole island would walk out. Does the Minister not agree?
So this is a very different situation where we have at the moment paid employees of the fire, ambulance and police force, but with the institution we have volunteers who are not paid. The institution is a charity. They provide lifeboats to this island at no cost to us whatsoever. We're in a quite peculiar situation in a way.
Can I just correct the Minister there, please, sir? Last year, the Lifeboat Guild raised something in the order of 496,000 a year, of which something in the order of 200,000 goes to run the Jersey station, and the rest of it is paid across to Poole. So I don't think it's fair to quite say that it costs us nothing.
So I'm very sorry, sir, but the Senator is not correct in what she's just informed the Assembly. She knows full well that monies that are collected in collecting boxes and donated in that way go to the general funds of the institution. Monies that are in a restricted bank account for the use in Jersey are left in wills.
Sorry, sir, I was talking about the money that's raised. I didn't say it went into the specifically Jersey Poole account. It just goes over to the RNLI account, which is held in Poole.
Moving on to the original part of the Senator's question, sir, I did explain to her last week that it is a free service. The institution have stations all around the country and parts of the coast where very, very, very few people live. Those few people can only donate a very small amount of money, yet they may still have a lifeboat which costs millions of pounds to buy and hundreds of thousands of pounds to maintain on an annual basis. It's absolutely wrong to say that it isn't anything other than a free service. And I accept, and I've said this openly, this island donates massive amounts of money to charities, and the institution's no exception. But that's the way it is.
Thank you, sir. I think from the questions that have been asked in this chamber and the strength of public feeling, it appears to me that there is an appetite for some sort of inquiry to find out exactly what happened so that we can move on effectively. Could I ask the Minister, when was the last time he spoke specifically about the issue of an inquiry with the former crew and coxswain? And if that wasn't recently, would he be prepared to speak to them again about this to find out why they feel an inquiry is necessary? He's spoken in previous answers about needing evidence before having an inquiry. Well, they may well be able to give him that evidence if he's prepared to speak to those. So would he be prepared to have that conversation with them? And I'm sure that myself and other members of this Assembly would be more than happy to facilitate that discussion.
Thank you, sir. To my best recollection, the last time I mentioned this to the ex-coxswain was probably 2, maybe even 3 weeks ago now, in a message where I did say to him that I wasn't sure if the best way forward now was a public inquiry. I'm quite happy to take the message from the Deputy, and I will contact the ex-crew and the ex-coxswain again and ask them again if there's any evidence that they can provide, which I can use. And if that's not possible, I will continue to pursue a direction of travel as regards a public inquiry.
To question 15, which Deputy Southern will ask of the Chief Minister.
Before I do, sir, may I ask to lift the defo on Deputy Higgins?
He was excused, I think, doesn't have to be lifted.
Oh, he's excused. Oh, sorry, apologies. Following the adoption of his government's policy of wage freezes and restraints since 2009 for public sector workers, which resulted in real terms loss in earnings of 7.5%, will the Chief Minister advise whether his modernisation offer will leave those employees, on average, a further 7% worse off in real terms, meaning a real terms loss of 15% in earnings from 2009 to 2020?
Chief Minister.
Thank you, sir. Public sector workers have not experienced a real terms loss in earnings of 7.5% since 2009. Furthermore, they are not expected to experience the 7% real terms loss as a result of workforce modernisation. Instead, we're seeking to proceed on a reasonable and affordable path which delivers a fairer, more sustainable and more flexible approach to our workforce.
Straightforward denial of clear facts. Is it not the case that the his department's financial forecasting body has said that the inflation is likely to be 3% or above for the next 4 years? And is it not the case that the average percentage award brought about by modernisation is 5.4%. 5.4% as against 12%. Is that not, or does it deny that black is white, black is black? Is that not the case, that that's at least a 7% cut in real terms?
So I think this is probably the fourth, if not fifth time that Deputy Southern and I have argued on these percentage figures across the Assembly. If he would actually like to show his workings or come and we'll compare statistical numbers, then I'm more than happy to do that, and it might be more productive than just arguing across the floor of the Assembly, because the figures he quotes are not the figures that I've been provided with.
Well, perhaps the Chief Minister can give us the figures that he's been provided with now in a public domain so that the public can hear, including the employees affected.
So I'm quite happy to do that. I do, of course, accept, as I have accepted previously, that there is a real terms loss since 2009, but not the 7.5%, a 4% loss. When it comes to the workforce modernisation, sir, there are many public servants who keep our island running, like ambulance staff, nurses, youth workers and manual workers, who will see an increase in their pay of between 7 and 22%.
So could the Chief Minister state how he arrived at the 4%? Is that an average across the board? Is it a median? Is it a mean? Could he explain further about the 4% figure, which is at variance with the our 7.5 figure?
So that is the reason that I made the offer that I did earlier, that there are a number of underlying numbers that arise to the differential in numbers, and it might be useful for us to have that conversation, and then we can stop arguing about numbers and we can accept a number which I think actually will make the point the Deputy is trying to get at. He's just trying to use a different number.
Thank you, sir. Will the Chief Minister tell the Assembly whether he feels he has a workforce with high morale when they've already lost 4%, according to his own figures, and 7.5% of the figures just explained here? How can he have a workforce with high morale and work with him to modernise the workforce when what's being contemplated are even further cuts?
£47 million extra is not a cut, sir, and many employees, as I've said, frontline staff, something that the Deputy asking the question, the Deputy has just done the follow-up question, I'd have thought would be supporting, sir. It's largely civil servants and officials that will see much slower wage growth over the period of modernisation, but frontline staff will see, in some cases, some substantial increases. I'd have thought both of those members would be supporting that, sir, rather than being critical of it.
Supplementary, sir. The Chief Minister is waffling as usual. The fact is that there has been pursuing for a while a policy of trying to reduce the pay of certain states groups because they believe that they are overpaid. And this is, in fact, even in my own time in the public sector, it was going on then. And will the Chief Minister not confirm that they are pursuing this policy, not only because they do believe some pay groups are paid too much, and will he identify them and say how much he wants to get their pay down?
So it's about, the Deputy knows that part of this programme is about equal value or equal pay for equal value. And those areas that I've just described will see quite substantial pay increases. Those are people on the front line. They should receive substantial pay increases. I know, sir, that the Deputy and the official original mover of this question would like to paint us as uncaring, everybody getting the same, cuts, and yet, sir, they know that's absolutely not true. More money for health, more money for health employees, more money for people on the front line, sir. Let's have a conversation about the numbers. Quite prepared to do that, sir.
Point of clarification, sir. No, the Chief Minister mentioned he believes equal pay for equal work. Does he agree that women should be paid exactly the same as men, then?
No, that's not a point of clarification. That's a further question, and we'll come to Deputy St John.
Thank you, sir. If the Chief Minister's figure is 4% and not 7.5%, and his figures for the modernisation offer are actually an uplift of 7 to 22% for certain workers, could he advise what the real terms loss is in earnings from 2009 to 2020, if any at all?
So I don't have all those detailed figures with me, but I'd be quite happy to provide those to the Deputy.
Final supplementary.
Sir, can the Minister offer an explanation of why, when his own figures, given some 2 months ago about the pay awards for public sector workers, revealed a figure of 7.5% below inflation between 2009 and 2000 and today, and that his own figures suggest that the percentage average change in the modernisation programme is 5.4% as against some 12% in inflation? How come he arrives at any other figure than 15% change in real terms downwards for public sector workers? That is the case, is it not?
So the Deputy knows I can't accept his figures. I don't actually have my calculator with me this afternoon and the detailed tables, but I'm, of course, as ever, sir, I enjoy doing that sort of thing, quite prepared to sit with him and we can do the calculations and agree on a number.
Come to question 16, which the Connétable St John will ask of the Minister for Health and Social Services.
Thank you, sir. Further to his written question, answer to the written question 175, will the Minister advise whether any changes have been made in respect to the acute services which it is planned will be available in the new hospital?
So there have been no changes since that written question was answered, sir.
Very well. Deputy Higgins, we've passed over your two questions. The first one was question 6, which you'll ask of the Attorney General.
Thank you, sir. Will Her Majesty's Attorney General advise who, in instances where a civil action is brought against a centeneer, I'll read this again. Will Her Majesty's Attorney General advise who, in instances where a civil action is brought against a centeneer, is ultimately responsible for the actions of the centeneer acting in either their prosecutorial role or policing role?
Attorney.
So taking first the centeneer's policing role, the constable of the parish is liable under Article 22 of the Honorary Police Jersey Law 1974 in respect of civil wrongs committed by members of the Honorary Police of the parish in the performance of their functions. This liability is on the same footing as the liability incurred by an employer in respect of civil wrongs committed by his or her employees in the course of their employment. Any proceedings in respect of a claim made under Article 22 must be brought against the constable or, in the case of vacancy, the senior officer of the Honorary Police for the time being. In relation to the prosecutorial role of the centeneers, under the 74 law, the power of the centeneer to charge is confirmed without prejudice to the powers of the Attorney General in the prosecution of offences. The answer tabled on the 1st of November last year to an earlier question from the Deputy made clear that any failure on the part of a centeneer in respect of his or her role as prosecutor will be considered and determined by the Attorney General pursuant to his supervisory role over the Honorary Police at customary law or his functions under the Police Complaints and Discipline Jersey Law 1989 and the Honorary Police Complaints and Discipline Procedure Regulations 2000. But to the extent that the civil action may arise from an act or omission of a centeneer in his or her role as prosecutor, Article 22 of the 74 law also applies, and therefore the constable is also liable. So in relation to civil claims arising out of either the prosecutorial or policing function, the proper defendant to a civil claim is the constable of the parish.
Supplementary, sir. Is that still the position since we changed the law regarding the role of constables as part of the honorary police? And secondly, what if constables are disavowing that they have any liability, as is the case in one case I'm aware of?
Yes, so the law remains unaffected by the change in the nature of the constable's function in respect of policing in 2012. In the case of any disavowal, it is right to say that under Article 22, subparagraph 4 of the 74 law, a parish may, to such extent as the parish assembly think fit, pay any damages or costs awarded against a member of the Honorary Police. So in circumstances where the constable was reluctant to do so, the parish assembly could refuse, it appears, to indemnify the officer concerned.
Deputy Tatty.
Thank you, sir. Have there ever been any civil action cases brought against the constable for in such cases?
So I'm unable to answer that question. I'd be surprised if there hadn't been, and I know that the parishes are insured in relation to such claims.
Final supplementary.
I'll leave it at that for the moment, sir.
And, Deputy Higgins, your other question was question 12, which you were going to ask of the Minister of Home Affairs.
Right, thank you, sir. Further to her responses to earlier questions on this subject, will the Minister explain how a member of the Jersey Police Complaints Authority, appointed to supervise a complaint made against the police, undertakes that role once appointed?
Minister.
Thank you, sir. As confirmed in the response to written question 9725 in 2016, the role of the Jersey Police Complaints Authority in supervising investigations into complaints regarding the conduct of police officers is as set out in the Police Complaints and Discipline Law 1999, in particular Articles 9 to 13 for the States of Jersey Police Force and 23 to 26 for the Honorary Police. Further detail as to how the JPCA undertakes its work was also provided in response to written question 382 of 2017. I think the Deputy is also aware that the Police and Complaints and Discipline Jersey Law 1999 and associated legislation is currently under review.
Supplementary, sir. Can the Minister, in plain English, without quoting sections, tell us what the role is of the person appointed by the chairman of the Independent Police Complaints Authority? Say what the role of the individual is as part of overseeing the investigation. That was the question.
And so I have directed the Deputy to the relevant articles of the relevant law, which have been in the past put in the public domain in an answer to the Deputy in the form of written questions that I have just identified. I don't really understand what more the Deputy wants.
Thank you, sir. Let me put this to the Minister then. My understanding of the role of the person who is appointed to oversee the police investigation is to make sure that a proper investigation is carried out. How can that be done? How can the person who is the person supposed to be overseeing the police sign off a report where the police have not taken a statement from the person who brought the complaint and did not interview the person who brought the complaint? How can that be considered an adequate investigation, and yet the person who is named as the reviewing person failed to do that job? Does the Minister think that's acceptable? So the police don't question the individual, don't take a statement, basically didn't do their job.
Sir, it appears that the Deputy is referring to a specific case, and of course I don't have knowledge of the case that he's referring to, so it's rather difficult to respond in a full and frank way. I am aware that the previous chair of the JPCA has offered to meet with the Deputy on many occasions. He's never taken her up on that offer, and I'm sure that the current chair would also extend a similar invitation, and likewise I would be happy to meet with the Deputy if he wishes to raise a specific point.
Senator Ferguson.
Would the Minister like to confirm that although the complaint is made to the Police Complaints Authority, the actual undertaking of the investigation is done by the Professional Standards Department of the police, and that on occasion the officer about whom the complaint has been made has actually written to the complainant to explain that the complaint has not been upheld? But basically, which seems a little odd, certainly, but basically the Complaints Authority merely subcontract the investigation to the Police Standards Authority.
Well, there are many points to make there. Firstly, as I pointed out in my original answer, the law is being reviewed at the moment, and I'm sure that there may be some changes falling out of that to the way that the work of the Police Complaints Authority is undertaken, but of course I cannot put the cart before the horse. Secondly, it's correct that the role is an oversight role currently, and but I am very grateful to the members of the Police Complaints Authority who are intelligent, independent members of our community who assist us by undertaking this work?
One supplementary.
Yes, sir. Will the Minister, I will come to the Minister with information, and I will ask her to look into the matter, and if she will review what the Independent Police Complaints Authority did or failed to do, would you investigate that matter if the evidence is brought to you? Because it was a total failing all round. And secondly, I'm not aware of the offers to see the former head of that body. If you've got the information, I'd love to see it. I'd love to meet with them. Through the chair. Thank you, sir.
So yes, of course, I would be delighted to meet with the deputy.
Well, it might be convenient, I think, to take the urgent oral question before the questions. Ministers, without notice, I'm not quite sure why it's listed there. So, the Conatable of St John, would you please proceed with that.
Thank you, sir. Will the chairman explain why pay slips are not being given to weekly paid manual workers in accordance with the Employment Jersey Law 2003?
That's the chairman of the State Employment Board.
Thank you, sir. The process for weekly paid employees has not changed. It is compliant, sir, with the Employment Jersey Law 2003, and there is no reason why employees should not receive their pay slips. Currently, weekly paid employees receive their pay slip at or before the time at which payment of wages is made to the employee in one of two ways: email in a PDF version or hard copy sent by post to a home or work address as requested by that employee.
Sir, it was the spouse of this individual that approached me, and on further investigation, that employee is not the only one. Another employee was informed, it's in your email, to which he said, I don't have an email. So I know of at least two manual workers who have not received their pay slips last week. Neither of them possess computers or have email access, and they've both been informed that it's in their emails. As they don't have emails, how has that occurred?
As I said, sir, in addition to the email version, a hard copy is sent if the employee requests it by post, either to their home or work address. If the constable gives me those names, sir, I'll make sure that that is put right and apologise to the individuals.
I regret, sir, I will not betray the confidentiality of people who have come forward. But I will, however, discuss with them and ensure that they do get their pay slips so they can come to you for the relevant apology in due course.
Sir, can I suggest, I understand the constable's reluctance, I wasn't suggesting he gave you the names today, but can I suggest that he advises them to speak to their line managers and request a hard copy as per our procedure, sir?
They have both done that and were both informed it was in their email, sir.
Very well. We now come to questions to ministers without notice. The first question period is the Minister for Home Affairs, Deputy Tagley.
Thanks, sir. Because of an inability of the Health Minister to act swiftly when it comes to medicinal cannabis for people in particular who might suffer from spasticity, MS, vomiting from chemotherapy, fibromyalgia, etc., these individuals either have to choose to go without medicinal cannabis or to break the law in either to procure it for their specific purposes. Will the Minister explain whether she is likely to advise the police, whilst the Minister continues to delay it in the Health Department, that they should not prosecute individuals who are using such drugs for medicinal use?
It's not a question for the Minister to deal with who is prosecuted, Deputy.
So the Minister is responsible for the police, I believe.
And she's not responsible for prosecutions.
No, sir. And so I'm not talking about prosecutions, but obviously the police are responsible for applying discretion as to whom they arrest and whom they investigate. So That should be my question. If I mentioned prosecution, sir.
I understood you to ask about prosecution.
Okay. But I'm actually asking about the attitude that the police apply and the discretion they apply to those medicinal users potentially of cannabis.
I'm afraid, sir, that I can't be any more helpful myself, because it's not the role of the Minister to direct the police in their operations either.
Deputy St John.
Thank you, sir. The Minister for Home Affairs has recently lodged the Criminal Procedure Law. Within the Criminal Procedure Law, it's suggested that they have given the Home Affairs and Education Scrutiny Panel a briefing on this law, which I do not believe that the panel have had. And could I ask the Minister that we ensure that there is a briefing had on this particular legislation, and whether she thinks it's appropriate for a law which is updating 150 years changes to the criminal justice system, that we debate this on the 16th of January.
Sir, I can only apologise to the Deputy if that scrutiny briefing did not take place. I was aware that I was under the impression that it had, and so I will ensure that one does take place, because I'm sure that Deputy, with her excellent memory, would have recalled it. It is a large piece of work that has been waited for a long, long time, and there has been a consultation period. There have not been a great number of responses to the consultation, but those that did respond were thorough and well thought through, and I'm sure we can go through that with the scrutiny panel as well. And so, without wanting to go on too long, the members of the legal community were also consulted to widely, as were the Criminal Justice Steering Board in developing this law.
So, supplementary. Notwithstanding the fact that this has been consulted on, does the Minister not agree that there should be thorough scrutiny of line by line in terms of the legislation with this particular law, and ensuring that it's fit for purpose for the flexibility of the future of the criminal justice system?
It's very important that scrutiny is given an opportunity to conduct their role, and particularly in terms of legislative scrutiny, which we often criticise ourselves for not conducting properly, and so I'm happy to work with the scrutiny panel to ensure that they can do this.
Deputy Minister.
Thank you, sir. It's on the subject of medicinal cannabis as well. Given the previous answers we had from the Health Minister indicating the difficulties there are with getting this through in the timetable we'd anticipated, could the Minister indicate what discussions have been had with the Customs Service and what work they have done in anticipation of this going through to make sure that they are allowing these products into the island and not accidentally taking them from islanders who might be travelling with those products?
Thank you, sir. That would be something that would, the role of the Customs and Immigration Service would be something that would fall out of the work that is intended to be done. And the Health Minister was expressing his apologies, I think, earlier for not expediting this piece of work, which is fully intended to happen. And so that is a piece of work that would be conducted alongside and following any progress in this area.
Deputy Sutherland.
Thank you, sir. Has the Minister read the response of the Chief Minister to written question 309 in June of this year, which showed that prison workers and police were 7.5% behind the rate of inflation over the period 2009 to 2016. And that as a consequence of this loss to these workers, would she consider and make representations to the State's Employment Board that they should be receiving more than 5.4% average, which is applied in the modernisation process when uniform branches engage with the modernisation process?
Well, sir, I am always very keen to talk to the Prison Officers Association and others who work in the Home Affairs team, and I have done so in the past. And if there is a problem, I'm sure that they wouldn't hesitate in coming forward to me to raise that with me, and I would indeed be engaged in conversation with them. But they have not as yet.
Deputy Teddy.
The Minister knows that there is a constituent in her parish constituency who suffers from spasticity issues following paralysis. And what would she say to him and other people like him when the question is asked, how long will he have to wait before he can legally use a product which is clinically been demonstrated to be beneficial for him without being criminalised? And what steps will she take to expedite, both as a parish deputy, but in this case as the Minister for Home Affairs, the work that's going on with the Health Department, which has already failed to meet its deadline for the end of this year in that regard?
I think we can all feel sympathy for people who live in pain, and although and I think as any member would empathise with somebody in that situation. So, sir, I will ensure that I help the Health Minister to push forward this piece of work, and I will encourage him to do so.
No other questions?
Sir, I didn't-
Deputy Higgins.
Thank you. Could the Minister explain what the Customs Department, or under her remit, is doing with Her Majesty's Customs and Excise in the United Kingdom, who are stopping parcels coming from Jersey, although they are below the figure for VAT and are gifts. They've been intercepting packages. In fact, there was an account put in the JEP the other day. I've had one stopped, and there's absolutely no reason why they should be detaining this. And furthermore, Royal Mail is charging people £12 to release it as a service fee. We're supposed to have free movement of goods if they're below £35 and they are not subject to VAT. If the Minister doesn't know anything about this, will she look into the matter and query it with UK HMRC?
So I'm afraid I didn't know anything about this, but I will, along with the Assistant Minister who has delegated responsibility in that area, certainly look into it and get back to the Deputy.
Deputy Southern.
Yes, sir. Further to the previous question, to what extent has the Minister engaged with fire, prison and the police over what terms and conditions might be changing in terms of modernisation of the workforce? What practices does she see changing, if any, at this stage?
So there's been an ongoing process with those bodies. The prison, that was before my time, but I have met with the chair of the Prison Officers Association and worked very effectively with him. I would always be happy to do so with our employees.
Sir, but at the heart of the question was, are there any particular changes in practice that she is aware of that may be engaged in the modernisation process?
I'm not entirely sure what the Deputy is referring to in terms of changes in practice.
To illustrate just a nonsense one, instead of being in charge of 2 prisoners, perhaps a prison officer might be in charge of 4 or 6 for a particular routine, whatever.
I see. It's a rather detailed and technical point, right, but that's something that's done at a management level. And for example, at the 2016 spending process in order to make a cut in the department. Sorry, I'm just giving an example, sir.
Minister, I really don't think you should be forced to ask a question which one doesn't know where it's going, if I may put it that way.
But I was asked to try and exemplify because the Minister didn't understand my question. sir. So I'm trying to be helpful. I know the chair might consider it particularly helpful, but I thought I was.
Thank you.
So I'll carry on with my examples, shall I, sir? I've forgotten. The example was not exactly, actually. It was slightly different. It was actually rejigging shift patterns in order to make a saving, and that's done at a management level under the direction of the minister.
Deputy Tadier.
With regard to prisoners who will be eligible to vote in the forthcoming elections, what work is being done in the prison to inform and identify those prisoners?
So I'm not aware, actually, of what work is being done, but I shall ensure that I ask the question, because it is important that we engage with those who will be able to vote. And if I remember correctly, there will be some work with the GREF in order to do so.
Does the Minister envisage, or will she talk to PBC about whether or not there might be a senatorial hustings taking place at the prison, or provision made for those prisoners who are eligible to vote to attend such hustings?
Do you know, actually, sir, that's sparking a little grain in my memory, and I do believe that I have heard talk of such a possibility taking place, but I will confirm that to members.
Any further questions, Deputy St John?
Yes, thank you, sir. The Care of Children Review Panel were advised that there is a review currently being carried out with regards to youth justice and with regards to the Prison Board of Visitors situation. Can the Home Affairs Minister advise what involvement Home Affairs are having in this review and what work is being carried out currently to support the Chief Minister in his work of care of children?
Sorry, I missed the very beginning of the question, but I think you're asking about a youth justice review. So the Assistant Minister is on the Access to Justice panel, and she is taking an interest in that area.
There are no other questions for the First Minister. Very well, that brings her part of the questions without notice to an end. We now come to questions for the Minister for Treasury and Resources, Deputy Lattley.
Thank you, sir. Is the Minister still seriously considering making higher education grants conditional on postgraduates returning to the island? Because I find this an affront to the development of our graduates, and that's what education is about, personal development. One can't stunt that development by making this sort of requirement. And it's so insular. If other nations were doing the same, we might not be able to hire in when we need graduates from the outside.
Sir, I'm not making that suggestion at all. I'm not quite sure, other than perhaps from some misplaced comments by the media, that may well be the case. I think what I was referring to was the fact that there have been, or is, a consultation process which has commenced today. There are a number of issues being raised by the Education Department in regard to that, which will run for around about a month through until the 12th or 14th, I believe, of January, at which point a decision will be taken as to any particular conditions or conditionality that will apply to the proposal for grant funding higher education, which I think is a positive step forward. But certainly there's no suggestion that that's going to be applied, and certainly not by me.
Deputy Greville.
Why did the Income Tax Department have to recruit members of staff from senior members of staff from the UK to deal with local tax matters and work in the department? And this new cohort of accountants are now sort of wasting many practitioners' times because they're quoting UK law and articles when writing for funds.
So the tax department is going through a transformational process at the moment. There has been a requirement to bring in additional staff. Indeed, first and foremost, there was an attempt to recruit locally, which was not successful.
And so some staff were brought in largely on a temporary basis to backfill and support the tax department, which is struggling at the moment in order to carry out its functions due to a lack of staffing appropriately qualified in order to do so.
Kevin Lewis?
Could I ask
Yeah,
a
I'm so sorry.
supplementary?
Supplementary.
Yes. Well, on that point about recruiting locally, does the tax department do anything to train up local accountants? I mean, I find it very difficult to believe that there aren't local accountants. This place is awash with accountants. That there aren't appropriate staff members to fill these positions. But does the department do anything to train young local people for?
The tax department, of course, has a number of excellent staff. It's simply the workload that it's being asked to undertake with this transformational programme which is causing the problem. And yes, the development of staff is a key aspect within all states departments, including the tax department, to ensure that staff are properly trained. And that work will continue as we move forwards.
Deputy Kevin Lewis.
Thank you, sir. Further to the recent lowering of stamp duty in the last budget, which is to be welcomed and could allow young couples to purchase their own homes, does the Minister not find this at odds with a proposed development tax, which, according to developers, could put up to £10,000 to £13,000 on a house?
So there wasn't a reduction in stamp duty. I think the Deputy might be referring to the UK, which made some alterations. Of course, our own regime in terms of stamp duty is extremely generous and supportive of those trying to get onto the housing ladder, more so than the UK system.
Deputy Mezza.
Thank you, sir. Could the Treasury Minister indicate how much per year he anticipates the recent policy on higher education funding, uprating those grants, how much per year that will cost, and could he also tell us where the funding will come from?
Yes, sir. Approximately £7.5 million, of which that's based on an absolute maximum take-up of the grant system. So, of course, the modelling has taken the worst-case scenario in that respect. I actually don't view it as worst case. I see it as a very positive thing, because we will have all our students who are qualified, therefore having the ability to access higher education. In terms of how that will be funded, £3.5 million will be funded through the removal of allowances, both to standard rate taxpayers and marginal rate taxpayers. And the balance in the period 2018 and 2019 will come from underspends. Largely those underspends are in the education department because, of course, the system as such at the moment is not allowing all the students to access the grants that are available. So there is an underspend there which will be utilised. If there's a shortfall, then it would be contingencies. And from 2020 onwards, the medium-term financial plan will need to find sustainable funding mechanism going forwards for around about £4 million per annum.
So the short answer to the second part of my question is that there is no long-term funding mechanism for this. Could he assure us that the funding for this policy will not be delivered by raising taxes on low earners or middle earners, and can he also guarantee that the funding will not come from cuts to other public services that we rely on?
Sir, there is a need for ongoing efficiencies across the states, full stop. That's been made clear. No, I'm not talking, Deputy, about cuts. I'm talking about efficiencies, which is first and foremost an important and embedded part of the public sector reform programme, and the Fiscal Policy Panel has made it absolutely abundantly clear that we need to continue with that programme of delivering efficiencies in the public sector to ensure that taxpayers' money delivers value for money, and that is the appropriate way forward. There is a strong belief that the funding for higher education, at the figures that I have indicated, can be funded from within existing resources.
Deputy Sutton.
Thank you, sir. Is the Minister aware of the answer to written question 309, which showed that his civil servants suffered a cut of 7.5%. Has the microphone been off for most of that? Is the Minister aware of the answer to written question 309 of 6th of June of this year, which showed that his civil servants were 7.5% worse off over the period 2009 to 2016 in real terms? And will he engage with his civil servants over negotiating with the States Employment Board over a further cut of 8%, which is proposed for civil servants in the modernisation plan?
Sir, the Deputy assumes that the Workforce Modernisation Programme is going to lead to the workforce, and he talks about my civil servants. So in fact, they are our civil servants. Everybody who works in the public sector is funded by the taxpayer and therefore delivers a very valuable service. And I should say that the Workforce Modernisation Programme doesn't automatically lead to loss. In fact, there is a very small number of employees that are going to see a loss. There are a large section, particularly of those that provide essential frontline services, that are going to see an increase as part of that particular programme.
Sir, if I may?
Yes.
Has the Minister studied the document produced under the name of Workforce Modernisation from the States of Jersey, which shows that civil servants in particular will receive a 3.3% award for the next 4 years, to cover 4 years when inflation will be 12%, they'll be 8.5% further behind than they were in 2009. Is that not the case, and will he engage with his civil servants?
So it's very easy for the Deputy to pick a small, isolated example out of a substantial document which is seeking to ensure greater fairness and ensuring appropriate pay for appropriate work. It's a step forward, the Workforce Modernisation package that is being presented, and I think that should be welcomed.
Will the Minister reconsider his words when he says a small group? It's 3,229 out of 5,000 who've engaged in workforce modernisation. It's the majority civil servants.
The majority of the workforce are going to see a benefit. There is a small percentage that are going to see a detriment to their position.
Deputy Teddy.
Thank you, sir. My question to the Treasury Minister follows from recent media coverage about Jersey expats who are having to pay 20% on their pensions living abroad. Would he be able to comment on the rationale for that, whether he thinks that is fair, and whether he is taking any note of the recent remonstrations that have been put in the public domain on this issue?
Yes, sir. That was a measure which was approved as part of Budget 2016, if I remember correctly. It's the non-residence relief for an estimated 500 or so people who are living outside of Jersey who will no longer be able to claim that particular allowance. It is estimated of those 500 that the vast majority will not see a direct impact, because there will either be DTAs in place, or indeed there are arrangements with foreign authorities whereby tax credits can be issued. There is, however, I accept, a small number of individuals who will be impacted, and I think that's what the Deputy was referring to, because there have been 1 or 2 cases in the local media which are being looked at by the tax authorities at the moment.
Senator Isaac.
Thanks, sir. Supplementary, if I may.
Look, come on, keep at it.
Thank you, sir. It's certainly not a policy that Reform Jersey voted for, even though it may have been in the 2016 budget. But the Minister hasn't really answered the question why it was passed. What's the rationale, and how can he justify the fairness, even if it's for a few individuals who are essentially being seeing their income reduced, but they've been taxpayers in the past and they're not using local services? Surely that is completely and utterly perverse and unfair.
It was first and foremost to try and simplify what was a very complicated system. There was, of course, a saving of around £500,000 or so for people who were living outside of the island and claiming a benefit that was resultant from Jersey. And as I've said, it was included in the budget proposals from 2016. And as such, the number of around about 500 people who are likely to be impacted by it, only 20 or so are those that were identified as a particular case, which have been, some of them have attracted some media attention.
Senator Joseph.
Thank you, sir. Would the Minister confirm that following some constructive discussions regarding the Amendment 2 concerning the hospital funding debate, that a revised amendment, which is shortly to be circulated to members, which simply withdraws part of that amendment that I made, details of that later, has the Minister's approval? And would he confirm that it is the proposition for the hospital debate which is being approved and not necessarily the actual report, which may change because of market conditions in the coming weeks before a decision on financial instruments are made? And is he content with where we have ended up?
Sir, it is correct to say that I have had some constructive discussions with Senator Joseph with regard to his proposed amendment. I would put just one small caveat insofar as I know the Senator has circulated his draft amendment. I haven't had an opportunity to read it yet, so I can't give unconditional approval, but I would suspect if it follows the thrust of the conversations that we've had over the weekend, then I will be supportive of it. With regard to his other point, of course, the report and proposition, the States generally approves the proposition. A report is there for additional information. The Senator makes a valid point, sir, insofar as market conditions could well change, and if market conditions do change, then that would need to be a matter that would be considered.
Deputy Messick? No. Deputy Preville?
Thank you, sir. Will the Minister accept a certain amount of responsibility for the aggressive and unnecessary tone of some of the letters sent out by the Income Tax Department? I had a 90-year-old constituent approach me this week in a state because of some IT blip. And I do know that some of the letters and communications that they do send out are unnecessarily aggressive. Does he take responsibility?
Sir, yes, I take all responsibility for actions that occur within my department, but the particular case the Deputy is referring to, I clearly have no knowledge of. If she would like to share that, I'm very happy to take it up with officers in the department, because it does sound somewhat disturbing.
Well, no further questions for the Minister. There's only about a minute left in any event. We now come to, there's nothing under J. We now come to K, statements on matters of official responsibility. The Chairman of the Privileges and Procedures Committee has a statement to make.
Yes, thank you, sir. I would like to update members on the appointment and work of the Referendum Commission. Members will recall that earlier this year the Assembly adopted the Referendum Jersey Law 2017. The law is intended to ensure that referendums in the island are held in line with international best practice, as set out in the Council of Europe's Venice Commission Code of Good Practice on Referendums. One of the Code's main recommendations is that referendums should be overseen by a permanent impartial body tasked with ensuring that referendums are fair and objective. One of the key provisions of our referendum law is therefore the establishment of the Referendum Commission. The Commission has two key functions. First, to advise the Assembly on the proposed wording of a referendum question. Indeed, a proposition for a Referendum Act cannot be lodged unless the Commission has published its opinion on the suitability of the proposed wording. And secondly, the Commission designates the lead campaign groups campaigning for each side in a referendum. PPC presented a report nearly 2 weeks ago to indicate its intended appointees to the Commission. Those appointments will take formal effect on Wednesday next. Nevertheless, the Commissioners have already met, a meeting they felt was vital in order to discuss the implications of the Assembly's recent decision that there should be a referendum on the role of the bailiff as President of the States. The Assembly has not yet made an explicit decision on when that referendum should take place. The question of timing was not addressed in the wording of the Chief Minister's proposition as amended and approved. Nevertheless, it was apparent from the debate that members had different views on the timing of the referendum, and that some members felt quite strongly it should take place at the same time as the elections in May 2018. The prospect of a referendum in May 2018 has been considered by the Commission. It has set out its views in a letter to me, which I am circulating alongside this statement. Members will note the Commission's view is that it is unlikely the Commission could do a thorough job in meeting its responsibilities under the referendum law if the referendum were held at the same time as the elections in May 2018. The Commission has explained its reasons for this view. Put simply, the relevant Referendum Act must be adopted by the 16th of February 2018 for the referendum to be held at the time of the May elections. Given the Assembly's current meeting schedule and the provisions of standing orders in relation to lodging periods, this would require the Commission to have reported on the wording of the question by the 2nd of January 2018. That timetable is impractical. The Commission has highlighted measures that we could take as members to address the situation. The Assembly could agree to reduce the lodging period for the Referendum Act, and a special meeting could be requisitioned for mid-February. The Commission has noted that such action would help the situation, but that it would not, from the Commission's perspective, resolve the challenges entirely. Understandably, the Commission takes its responsibilities under the law seriously and wishes to do a thorough job in advising the Assembly on the proposed wording of the question. To do so would still be difficult in the Commission's view, even with a reduced lodging period and a requisition meeting. The Commission has therefore explained that it cannot guarantee the timetable for a referendum in May, and that it is not confident that it can be achieved. Members will note that the Commission has nevertheless anticipated members may wish to have the option of a referendum in May 2018. The Commission is therefore exploring the practical feasibility of a referendum at that time, for example by arranging focus groups, but it has stated that it can only endeavour to meet this timetable. There is evidently other work to be done in respect of the referendum and the proposal that the bailiff cease to be President of the Assembly, aside from what the Commission is doing. Members should be aware that PPC will itself be undertaking work. There are prospective legislative changes to consider and prepare to the States of Jersey law and to standing orders, and the Referendum Act itself needs to be drafted. PPC will be undertaking this work to ensure that from the committee's perspective, members have the various options available to them in terms of the referendum's timing. However, in light of the views expressed by the Commission, I think members may need to prepare themselves for the fact that a referendum in May 2018 may not be practical. I understand the Commission is meeting again later this week to continue its work and discussions. I will ask the Commission to keep PPC apprised of what is happening, and I undertake to update members as and when further information and advice from the Commission is forthcoming. Thank you, sir.
Well, we have up to 15 minutes for questions.
Sir, I wonder if the Chairman would address the issue of the referendum question, because the proposition that was adopted by this Assembly used the word presidency of the state, sir. And my concern was that the word presidency might not be understood, and I mean no disrespect to Islanders or you, sir, or any member of this Assembly or anybody else, but it is the wording of a referendum that is absolutely vital, and that's what the Referendum Commission would be asked to consider. And has the Referendum Commission, albeit in their draft or form, or their sort of nascent form, actually considered the problem of the question and whether or not that question is going to be understood in terms of presidency, and that automatically means speaker? Because sometimes it does. It depends what language you're talking about and how you emphasise it.
Yes, of course, sir. It is vitally important in any referendum that the public understand the question. And this is why, one of the reasons why, we have created an independent referendum commission. And part of their role will be to advise us on how the question should be phrased, and they will use the public to help them understand that by having focus groups and meetings with members of the public to get reactions from how the question might be fairly phrased. And that is so vitally important, not in just this referendum we're going to have in 2018, but any referendum. It's vitally important that the question is fair. However, at the end of the day, it's down to the states. But the states will be advised by the independent commission. So they will be working on that as we work towards the referendum.
Any other questions that come up? If not, Dr. Teddy?
So effectively what the Chairman is saying, it's down to a future States Assembly to decide on the referendum question to approve it, and indeed whether or not the referendum goes ahead at all, and indeed whether or not additional matters could be added to the referendum for a more holistic question to be put to the public if it is indeed put at all.
I don't think that's quite what I said. What I have said is that to have the referendum in May would be challenging. But nevertheless, the Commission will be working to advise us on to whether that would be practical in enough time to give them the opportunity to do their work thoroughly and advise us thoroughly. And at the same time, it would be down to the states to decide, if that were to be practical from the Commission's point of view, whether the states wanted to reduce the lodging period for the Referendum Act and have a special meeting of the states on February the 16th to debate it. So there's two parts to that. It's up to the Commission to see if they can do the work, and it's up to us as states members to act on that work if we're going to have a referendum in May. At the end of the day, if it's in May or later, it will be the next Assembly which will make the decision. It's up to the states whether they accept the Referendum Act, and it'll be the states who decide, in whatever form they are, whether they accept the results of the referendum.
Thank you, sir. Does the chairman of the Privileges and Procedures Committee endorse previous reports by that committee which stress the importance of having a referendum question that is clear, concise, and on one matter only?
Yes, sir.
Any questions?
Thank you, sir. Whilst fully respecting the independence of the referendum commission, I just want, I can't really understand how difficult a question on asking whether we should keep the bailiff in this assembly or not is. It seems relatively straightforward to me. Now, we all know, sir, that for a referendum to get the true public opinion from a referendum, it needs to be held at a time when most people are likely to participate, and that is at a general election. And I know, sir, there might be some games here, because some members might feel that by putting it off or putting it back to another time, a lower turnout might produce a different result. From my point of view, sir, and I know I share this with another of members, we think it's important that we try and do this at the next election. And will the chairman of the PPC undertake to do whatever he can to ensure that is the case?
So, absolutely, sir. The Commission have indicated that they are doing the work to try and give the states the opportunity to have the choice to have the referendum in May next year. They have indicated, however, that that might not be practical, but they are doing the work to try and give the states the opportunity to do that if the states so wish.
So, notwithstanding Deputy Masson's question to the chairman, does the chairman have any sympathy of the view that a referendum which deals with the whole of the composition of the States Assembly, including its presiding officer and the membership of its of this assembly, which has so bedeviled so many assemblies, potentially has merit in not only being so important that it would get voter turnout high, and would deal with effectively what is the overall issue of the composition of the States Assembly.
Sir, the states have made a decision based on the Chief Minister's proposition as amended that the bailiff should no longer be President of the states, subject to the public agreeing to such a thing, to such a move, in a referendum. And that is the only referendum we have before us. We have tried, PPCs in the past have tried to put propositions regarding the composition of the states before the public. But every time, the last time was with Deputy Massel was chairman. I was in the committee, and we were going to put to the public the clothier proposals. But no, that got hijacked as well by the then Deputy Green, who brought an amendment that it should just be simply on the constables, when he knew what the answer would be, and all of us knew what the answer to the referendum would be. So it was a waste of time and money, but did not give the public the opportunity of expressing their views on the clothier proposals. If someone would bring a proposition that we do that, and that was successful in the States, then of course we would work to it. But the proposition we have before us, the proposition the States have agreed, is there would be a single question referendum on the bailiff's presidency of this Assembly. That is all.
Deputy Mezek.
Thank you, sir. Looking at this letter and reading between the lines, does the chairman not actually consider it the case that if we're to have a meaningful referendum which is in line with the Venice Commission's Code of Good Practice, where there's appropriate focus from the public and where resources is given to the public before the referendum, that in actual fact it's more than challenging to have it on election day, but it's actually impossible, and that to arrange it we would have to break so many rules and standing orders that it really would be inappropriate on an issue of such constitutional importance?
On that question, sir, I will be advised by the Referendum Commission, which is their job to advise me and this Assembly, and we will bring an appropriate Referendum Act at the appropriate time. The Commission say it's challenging. I agree it's going to be challenging. I think they are prepared to make the effort, and all I can do is keep the States informed of what their views and opinions are on this matter.
Teddy?
Following on from a previous questioner, the context, of course, of this goes back to at least 2001 and the Clothier report, and the chairman, I know, has long himself said publicly that the public have never had a choice on Clothier. They've never been able to vote on it. So is it actually perhaps the job of the Privileges and Procedures Committee to consider contextualising and expanding the question if it is put to a referendum, i.e. should the full recommendations of the Clothier report from 16 years ago now be implemented, yes or no?
Sir, the States have made a decision on basis of the referendum question. I do not want to bring forward another proposition, as Deputy Massel did 4 years ago, to have that thrown out and then we have no referendum whatsoever. The States, the public have been asked to make a decision on one issue only, and that is the issue that the Referendum Commission are working on.
Senator Courts.
Thank you, sir. So I thank the chairman for his statement and the circularisation of the letter from the Commission. I want to follow up on the issue of best practice for referendum. I think Deputy Mezek in his question asked about it. I want to go one further, sir, and my reading, although it's only a skim read, of the Commission's letter doesn't actually pinpoint that as an issue. I'm very grateful for them wanting to do their work speedily in light of the Assembly's decision. But I wonder, sir, if the Chairman could revert to the Commission and ask for their opinion on whether pushing this decision forward, removing those barriers that they perceive, would actually comply with the Venice Commission's Code of Good Practice, and moreover whether it would comply with other international standards around holding referendum, which might help the Assembly inform its decision about whether it needs to have a special meeting or push it through speedily.
There is no question that the Commission want to do their work thoroughly and following best practice, and that they will continue to advise the PPC, and PPC will continue to advise the States on what stage they've reached. But they want to be thorough, they want to be as professional as they possibly can be, and to provide the right question at the right time for the public to consider, sir.
Teddy?
Thank you, sir. 3.3 of the Venice Code on Good Conduct of Referendums talks about funding, and it says that funding must be transparent, particularly when it comes to campaign accounts, and that also each campaigning party should abide by the cap on spending, and that if that is exceeded, that the vote must be annulled. Now, can the Chairman tell us if it is envisaged that there will be spending caps for each campaigning party during the referendum, and indeed whether funding will be made available, public funding, to each referendum campaign group, as per the referendum code recommendation.
So that matter has not yet been considered by the committee and will be included in the Referendum Act, which comes forward in due course.
And so, supplementary, would the Chairman ask the committee to look into those issues, particularly because it seems to me it's one thing to have a question, but if the whole apparatus around that is not, if we don't have a fair and level playing field for all campaigns and meet best practice in other areas, it seems pointless, whatever the question put to the public, if it's not going to be fair and potentially could be challenged.
Yes, that's absolutely right, sir. No, there is no doubt in my mind that that's exactly what we would do. I mean, that's a given as far as I'm concerned.
Any other questions for the Chairman? Well, we come to the next statement, which is to be made by the Chief Minister.
Thank you, sir. On Tuesday, the 5th of December, EU finance ministers at the meeting of ECOFIN, the Economic and Financial Affairs Council in Brussels, approved the outcomes of the initial screening exercise conducted by the EU Code of Conduct Group on business taxation. The Code Group's assessment resulted in the production of an EU list of non-cooperative jurisdictions for tax purposes, known colloquially as the EU Blacklist. 17 jurisdictions have been identified as non-cooperative. Jersey, rightly, is not on that list. The ECOFIN conclusions have confirmed Jersey's status as a cooperative jurisdiction, engaged in a constructive dialogue with the EU and committed to complying with EU and international tax standards. This outcome reflects the island's well-earned reputation for delivering the highest standards of tax transparency and information exchange. We have cooperated fully with the Code Group throughout their screening process, consistent with Jersey's pursuit of a good neighbour policy with the European Union. Jersey makes an important contribution to the EU's growth story. The island is a conduit for 188 billion euros of foreign investment into the European Union, excluding the UK, equivalent to 4% of the bloc's total net international investment. In addition, that investment supports in the order of 88,000 European jobs. The process followed by the Code Group initially identified 92 countries for screening. Following a tabletop review, the Government of Jersey received tailored questions from the Code Group Secretariat in June and August 2007, to which we provided detailed responses. In November 2017, letters were sent to all jurisdictions informing them of the outcome of the Code Group's work. Where necessary, a political commitment was requested within a specified time frame to addressing any concerns identified. The Code Group considered 3 sets of core criteria against which jurisdictions were assessed. The first were those that a jurisdiction should fulfill to be considered compliant on tax transparency. This can be satisfied through commitment to the automatic exchange of information, membership of the Global Forum on Transparency and exchange of information for tax purposes with a satisfactory rating, and signature and ratification of the OECD Multilateral Convention on Mutual Administrative Assistance. Jersey satisfies all these criteria. The second set of criteria related to anti-BEPS measures being implemented. These criteria are satisfied by membership of the Inclusive Framework on BEPS. Again, Jersey satisfies these criteria. The third set of criteria were those a jurisdiction should fulfill to be considered compliant on fair taxation. Concerns were highlighted by the Code Group that Jersey did not satisfy criteria 2.2, relating to the existence of tax regimes that facilitate offshore structures which attract profits without real economic activity. In order to maintain our status as a cooperative jurisdiction, I have made a written commitment to address these concerns by the end of next year. I have repeatedly said that Jersey is a jurisdiction of substance and that Jersey Financial Services Commission undertake certain economic substance tests prior to the approval of new regulated entities. Notwithstanding the positive work already being undertaken, I have made a commitment to discuss and address the concerns of the Code Group by the end of 2018. This work may include changes to our regulatory and legal framework and additional accounting and reporting obligations. We have already begun the necessary preparations to enact these measures, having regard to the Code Group requirements and Jersey's best interests. To ensure that this process will be completed by the end of 2018, the Government have produced a comprehensive timetable that includes consultation with industry, the publication of draft legislation, and scrutiny and debate by this Assembly. That timetable is reflected in our most recent correspondence with the Code Group, which has been provided to States members alongside the text of this statement. This is not a time for complacency. Whilst the island has achieved cooperative status, we must address the concerns of the Code Group within the agreed timetable. ECOFIN has confirmed that the listing process is not a one-off, but that jurisdictions will be subject to regular assessments by the Code Group. We will be working to ensure that the island's interests continue to be well represented in Brussels. Since 2011, the Channel Islands Brussels office, CIBO, has provided a permanent presence in Brussels, representing the Channel Islands to the EU institutions. The work they have undertaken has been instrumental in our interaction with the Code Group and in ensuring that officials and representatives of the Member States have an accurate understanding of Jersey's constitutional position and the regulation of our financial services industry. Alongside the Minister for External Relations, I will continue a regular programme of meetings in Brussels with representatives of the Commission, MEPs and the permanent representatives of Member States. I should also emphasise that the Government has worked closely alongside the Government of Guernsey in line with our joint commitment to engage in Brussels and to meeting international standards. The Chief Minister of Guernsey and I have travelled to Brussels on several occasions, including meeting with Pierre Moscovici, the European Commissioner for Economic and Financial Affairs, Taxation and Customs. I am certain that the close partnership between our two islands will continue throughout our ongoing engagement with the Code Group and in other matters, including Brexit, in order to meet the common objectives of the Channel Islands. Jersey's reputation as a well-regulated and transparent jurisdiction that supports the development and implementation of international standards is of utmost importance to the government of Jersey. In November, our commitment to meeting the highest international standards was recognised by the OECD's Global Forum when we were rated as compliant across all 10 areas reviewed. Sir, one of only 6 jurisdictions globally to receive this rating. We will continue to embrace the new rules that the global community identifies to address emerging risks and practices in cross-border finance.
Time to open questions. Deputy Lappy.
So I think the Chief Minister must be congratulated for leading the delegation to Brussels and negotiations on our behalf. I'm quite certain that the Chief Minister simply does not get, whatever our political sometimes differences, the credit he deserves for his work ethic, the man-hours he puts in, and his energy on behalf of the island, and I'm happy to pay tribute to him. I just wondered, has any work been done on estimating the extent to which the island might be sailing close to the wind on the economic substance issue?
So I thank the Deputy for his comments, but any person, sir, in my position knows that it is the team that surrounds one, ministerial colleagues, but most importantly, the officials that do all the legwork. And so it is they that I congratulated last week for all their hard work paying off. So we have started now engagement with industry. setting up a high-level working group together with technical and detailed working groups underneath. They will be tasked with understanding financial implications of various measures that we will then go and discuss with the EU.
Senator.
Sir, many people have suggested, including some members of this Assembly, on regular occurrences in the last 10 to 18 years that I've been here, the end of the financial services and professional services industry in Jersey. So a previous senator, former Senator Cyril Marco, used to apparently say, confidence is the name of the game. I wonder if the Chief Minister, based upon his statement, could give islanders some confidence that he believes that the future for our professional and business services sector on which this statement is made and these adjustments that we made can be, with ongoing work, as good in the future as it has served us in the last 20, 30, 40 years.
So I thank the Senator for his question, and as the previous questioner thanked me for my work in this regard, I thank the Senator for his work in supporting and building relationships around the globe which help us arrive at the conclusion that the EU had last week, sir. I am absolutely confident about our future. It is not blind optimism, sir. It is based upon what I experience day in and day out from financial and business services professionals in our community and the conversations and engagement that I have around the globe with regard to what Jersey does and what Jersey does well. And the overwhelming message that I receive, sir, is, Chief Minister, when we engage with Jersey, we feel that we are engaging with the best. Continue with your policy of meeting relevant international standards. Continue with being at the forefront of setting the standard. And that is why, sir, in my closing paragraph of that statement, I wanted to reiterate to members and to the community at large, it is not just me making political statements. It is what the OECD peer review group say when they have reviewed us. And these reviews are not easy, they are difficult technical reviews. One of only 6 places across the globe, sir, we have a future. We have a future that we can be positive about, but we must not take it for granted or be complacent. We must continue to meet those standards, engage with our detractors, and show what we have to offer to the world. And I'll stop, sir, because I'm aware.
Thank you, sir. We mustn't be complacent, but of course, if you ask difficult questions, you'll have your motives questioned on the floor of this Assembly. So, one of the countries that is on the blacklist is the murderous dictatorship of Bahrain, where the Chief Minister visited last year. This is a country that routinely murders people who speak out against the government and abuses people based on their religion or their sexual orientation. Since there being morally dodgy wasn't enough to give the Chief Minister cause to take another thought about whether we should be associating with them, does the fact that we know that they're financially dodgy give him cause to think that perhaps we should maybe give it a rest engaging with dodgy countries like this?
So sometimes political engagement in this Assembly is extremely gentlemanly. I'm not sure what the appropriate word to describe gentlemanliness is, and that's as it should be. But for my part, sir, there are times when I have to be absolutely clear. And when I hear members of this Assembly parroting back to me what I hear from our detractors, I will say so, sir. And if I get criticised for it, that is part of political dialogue, and we should call it as we see it, sir. The members of this Assembly sometimes stand up time and time again and say one thing and then do another. I believe we have a financial services and business sector in this community that we can be proud of, and we will continue to follow best international standards. When it comes to the issue of Bahrain that the Deputy just referred to, sir, he knows we follow British foreign policy. I was welcomed there, and throughout my visit in Bahrain, I was escorted by the head of the British mission there, and they support the work that we do, and we, sir, as being part of the British family, support the work that they do as well.
Supplementary, sir. He says he calls it as he sees it. I mean, I call it as I see it as well. I see someone who chooses to question people's motives because he has nothing smarter to say, so instead engages in petulant behaviour like that. What I'd like to know from the Chief Minister, seeing as we talked about this complacency and how that is something that gets jurisdictions into hot water, would he welcome well-meaning questions, sometimes those questions may be difficult, asking us to find out the detail of this, because whatever picture he might like to portray of us, we support Jersey being first class in the world, as we know it already is in this area, and we want it to continue to be so, and we don't believe in complacency, which is why we ask questions of the practicalities on the timetable, on what that means on the ground. So rather than batting these questions aside with nothing smarter to say and instead being rude and petulant, could he endeavour to take this debate to a higher level where questions are answered honestly rather than questioning the motives of those who actually care very deeply about this island and want to continue to see it prosper?
Sir, it was his party, forgive me, was it not, that was allowed to suggest that we are on a grey list when there is no such list. Exactly the terminology that others, sir, have said we're finished. And, sir, some members of his party have said exactly the same. The end of the world is nigh. Jersey will no longer have a financial services sector. We will, sir, because we are meeting the international standards, sir. I'm perfectly happy for them to ask me questions. I've provided the timeline that I've provided to the Code of Conduct Group this afternoon, and I will continue to engage in a constructive and positive matter because I am not complacent in this regard, sir. But what I will not allow is for members who are against our financial services industry, who think it's failing, who think it has no future, to pretend otherwise.
I'm sorry, Deputy, if I heard you correctly, you accused the Chief Minister of being a liar.
Sir, the Chief Minister stood up and he said that members were against the finance industry. That was clearly a direction at us because I was the one asking the question. I said in my remarks that I support the finance industry.
No.
If the comment was addressed...
No, Deputy. The question is about the use of the word liar.
I'm trying to help you, sir, by explaining what I meant. If the Chief Minister was not referring to me, then I'll withdraw the comment immediately. If he was referring to me, when I've just said I support the finance industry, then I can't in good conscience withdraw my comment.
Even if he were referring to you, that is not a parliamentary accusation to make. Would you please withdraw the word?
Could he answer my question before I decide whether or not to do that?
Even if he were referring to you, it is not a parliamentary
Sir, I believe that I am being impugned by what he said. I can't in all good conscience not defend myself because I believe he has said something untrue. I'm prepared to give way to him if he wants to say something to assist me on this.
Well,
I stand by what I said, sir. Perhaps the Deputy forgets something that he said to a visiting attack group in Jersey perhaps a number of years ago.
Sir, I've said nothing to any attack group. He is continuing to be dishonest. I can't withdraw it, sir. I can't withdraw it. He's being dishonest.
Deputy, I must ask you to withdraw the accusation against Chief Minister of being a liar.
Sir,
Chief Minister.
No, sir, I must correct something. I'm just being told that it was a different member of the party, not the member that's asking the question now, and therefore I apologise.
And what did they say? What did they say? He does not know what they said. He's making things up.
I'm sorry, this is not a moment for debate. The question is one of order. To accuse the Chief Minister or any other member of being a liar in this Assembly is not acceptable parliamentary practice. Would you please withdraw it?
On the basis of him saying it's not me, I'll withdraw it. And that's the only basis under which I do it.
Thank you. Deputy Sutton.
Is it my go?
It is your go, and then it's Deputy Martin's go. And but perhaps we can get back to asking questions about the statement, which is the purpose of the question. Chair.
Of course, there is no grey list, specifically. There is, however, the existence of tax regimes that facilitate offshore structures which attract profits without real economic activity. Item 2.2 of the ECOFIN statement. On that list, it says Bermuda, Cayman Islands, Guernsey, Isle of Man, Jersey, and Vanuatu. Does the Chief Minister accept that we have a regime which facilitates offshore structures which attract profits without real economic activity? Because if he doesn't, then there's no action to be taken, and yet he's outlined some actions in order to ensure that we don't attract profits without real economic activity. Is that the case, or does he accept that that's exactly what we do?
So I'm pleased that we've now finally got to the wording of the document and what it is that the EU has said, sir, pretending something otherwise. The Deputy knows, sir, that what the EU say with regard to that criteria is that they have concerns whether we meet that criteria or not. Something that I have been speaking about for weeks, even before the EU published their list of non-cooperative jurisdictions for tax purposes. And I've spoken to the EU Commission, EU representatives about engaging with them and entering into dialogue in what we can do and how we can give them confidence that we do have economic substance and how we can address their concerns, and that is the policy that this government is following, and it is what I will continue to follow, sir.
Sir, if I may, supplementary on the timeline. I note the timeline produced by the Chief Minister, and the thing that is missing from it is any feedback to this chamber, to this assembly, on their findings of research or their conclusions to what to do next until we get something lodged. Will the Chief Minister please commit for once to actually fully informing this assembly of what his research says and what his conclusions are coming to before we have to debate them in this House?
So I can certainly consider how we can engage. We will be expecting to engage appropriately with the scrutiny panel. One will have to be mindful of market sensitive information. These are important bilateral dialogues between the Government of Jersey and the European Commission, together with my fellow Crown dependencies. We want to ensure that they are conducted in an appropriate way, but we will find a mechanism, sir, to communicate with States members as well throughout this process.
Deputy Martin.
Yes, I think my question actually follows on there. The Chief Minister's statement, sir, makes a couple of commitments by himself in the External Relations Minister and to work to the end of 18. I hope the Chief Minister's got a crystal ball, but will he be in this job then? And it's just a question, sir, because he's made commitments, but he does say in the sixth paragraph down that he will bring something to the House for debate by this, and I'm reading it, sir, as this Assembly. So will that be, is that correct? Because other than that, I think the Chief Minister is sort of tying the hands of possibly the next person, maybe rightly or wrongly, but he's making commitments that he is saying we should be assured by, but I don't think it's in his gift to give, unless I'm reading the statement wrong. Can he assure me that it is in his gift to give, please?
So it's normal governmental practice when engaging in international relations to enter into commitments and agreements with foreign governments, and one's successor, whoever that is, of course, has to take the view about whether they believe that continuing to commit to, continuing to follow through on those commitments and that engagement will be a decision for whoever the next Chief Minister is. And we know that there are public elections, and then there will be an election for Chief Minister and an election for an external relations minister. But, sir, I believe it would absolutely be foolhardy for any person taking on this role to suggest that Jersey's future is in anything other than meeting the international, relevant international standards and the commitments that I have given on behalf of this government to the EU.
Well, that brings the question time allowed for questions on the statement to an end.
Sir, is it possible for it to be extended by 5 minutes to allow for the time we had for the unnecessary arguments?
Well, I think they were not unnecessary arguments, but I have already extended it by 3 minutes. Very well, I will continue for another 2 to make up the rest. Deputy Higgins.
Thank you, sir. And these are to the point. There are 2 questions for the Chief Minister. One of them is he was trying to find out what economic substance means. Has he had any further talks with them? Have we got a definition of economic substance? And secondly, he says that this work may include changes to our regulatory and legal framework and additional accounting and reporting obligations. We have already begun the necessary preparation to enact these measures, having regard to the Code Group's requirements and Jersey's best interests. So, first of all, have you got a definition yet of economic substance? And secondly, what work have you started? What regulatory and legal requirements have got to change?
So the Deputy knows that there is no definitive definition of economic substance, and that's why it is dialogue that is being entered into. The Deputy probably also knows, sir, that the work that the OECD are doing around economic substance, of course, has concluded in the BEPS inclusive framework, has concluded in country-by-country reporting, but an actual definition of economic substance has not been agreed, and nor has it been agreed by the EU either, or the Code of Conduct Group, which is one of the difficulties which we found ourselves in trying to answer questions about economic substance when there was no universally accepted definition. There are some definitions in some laws around the globe, and we started to look at what those might be. We have also acknowledged, sir, that the economic definition
time is short.
for
Can you answer the second part of the question? So we get 2 answers.
for economic substance could be very different for an investment holding company or a fund or a trading company. And it's all of those issues that we are now starting to consider. We've started to look at some piece of legislation to see if they could be amended for notification regimes. I've also spoken to the EU Commissioner about perhaps having a bilateral tax treaty with the EU directly, and from our initial discussions and thoughts, it would seem to me that that probably would be the best approach.
That brings questions to an end. So I noticed it's 5:30 very nearly.
Propose the adjournment. Sir, if I may, before the adjournment, I just wanted to make a point, sir, that members will note that there's an amendment to the amendment for the Constable of St John's, which has been lodged, I've lodged, and I just wanted to ask members if they would accept taking that tomorrow, and I would like to just explain the reason why. I've had very constructive discussions with the Constable of St John's in relation to his amendment. There were some errors in the amendment with regard to numbers, not the fault of the Constable, but nevertheless the numbers that he took from a previous proposition have now changed, and there were some unintended consequences as well as a result of the amendment that he had proposed. So we have worked to create an amendment that does work for him, I believe, and for us, and delivers on the Constable's objectives. And for that reason, sir, the amendment was lodged. I believe the Constable is going to accept the amendment to the amendment on the basis we worked on it together, and I will be accepting his amended amendment as a result of that, if, of course, members are minded to accept it, sir. But I just felt it was appropriate to ask the question, sir.
So you ask members to agree to reduce the lodging period to allow the second amendment to the Contabs amendment to be debated tomorrow.
In short, sir.
And that is seconded, no doubt. Members happy to do that, to reduce the lodging period? Very well.
Sir, there is the question that I asked the Minister in the questions without notice is that there is similarly an amendment to the second amendment, which you have kindly approved, and the GREF have been busy working on actually circulating to members, which is being in the process. I think it is being lodged, but it's not in members' hands.
It hasn't been lodged yet, has it?
Well, it's been approved and
I don't
circulated.
think you can ask members to agree to take a debate on something which hasn't even yet been lodged. That would be a first, Senator. Even for you, if I may say so.
Well, it puts me in a very difficult position, sir, because it's not the GREF's fault and it's not my fault that I was delayed.
Surely the position is that
it's in exactly the same position. I just wish to alert members, sir. Sorry.
Senator, surely the position is the paperwork will be on my desk tomorrow morning. I will announce the fact that it's been lodged, and you can then apply to have it dealt with straight away. But as a matter of form's sake, I think I prefer to see it lodged before we decide to take it.
Fine. Is it fair for me to say to members that an amendment has been processed, is in the process of being printed, it has been approved following consultation, and that a reduced lodging period will be asked in the same for the same reason, and I'm in an impossible position.
Well,
I get criticised either way.
I don't know if it's appropriate or not, but you've said it. Very well, we'll now adjourn until 9:30 tomorrow morning.